Thank you. We are on the record. We will start with our first and only docketed item today. That is docket number 2022-014, cause number 478-01. In the matter of the request for agency action of FINLEY Resources Incorporated for approval of its applications to commingle Green River and Wasatch Formation production from the Lazy River 12-10-9-19, 12-14-9-19, and 12-15-9-19 wells located within Section 12, Township 9, Range 19 East. I will now call for the appearance of counsel.
Fred McDonald of Counsel of Lear and Lear on behalf of the petitioner FINLEY Resources, Inc.
Tony Hunter for respondent IP LLC.
Trevor Gual with the Utah Attorney General's Office on behalf of the division.
Before we begin, we do evidently have a motion to continue that was submitted. I believe that was submitted by Mr. Hunter. Mr. Hunter, would you like to speak to that?
There's a little bit of discussion after the motion. The motion to continue was, in a manner of speaking, embedded in our response. And Mr. McDonald then responded to that. We, however, have had a discussion outside, and we have decided and agreed among the division and FINLEY and IP that we'll go ahead and address it as Mr. McDonald raising a new, fresh objection, which strictly probably should have been raised here for the first time, but no one really has an objection to the order. However, I will be responding to Mr. McDonald's objection, and then he will then rebut. So we'll just treat it as a little bit out of order and just try to get through that piece first and foremost. Then the board will have the opportunity to deliberate or grant or deny, and then we'll proceed or not proceed as the board decides with the rest of the hearing.
Is that your understanding?
That's fine.
Okay. Okay. Well, then I will give the time to Mr. McDonald.
Thank you, Mr. Borden. International Petroleum in the response requested for a continuance, and they outlined several reasons which are kind of summarized in paragraph 10 of their response. But if you carefully review all of the information that they say they need and the additional time that they need, it all relates to spacing. And you need to understand that this is a commingling application here. What we're dealing with is the production through a single wellbore of production from two different formations. And as we get into this, you'll hear that there really isn't any difference here. What International Petroleum is really trying to do is say that they have rights to the production whether it's commingled or not. And that's done through a spacing order, not a commingling application. They have other avenues and remedies to seek all of the relief that they're trying to do through petitioning the board for their own spacing order. So it's very important for the board to understand the difference between what is in front of you today, which is a commingling application for 3 particular wells, which we will address and justify, whereas they're asking for a continuance to create a spacing so that they can share in the production from these wells. So the purpose being is also these applications were filed in December of 2021, 7 months ago, and nothing has been done in the interim until the protest in this hearing now to seek a spacing. So we have difficulty trying to understand why this matter needs to be continued on that situation. The key element here is to remember the line from the Cowling case, which is kind of a key case in oil and gas law in this state, that you do not have correlative rights until there is a spacing order. And if you do not take action to protect your correlative rights, then you waive that until a spacing order is in place. So the remedy is to seek spacing. All the information they are seeking to justify a continuance deals with spacing. It doesn't deal with commingling. And therefore, we ask you to proceed with the hearing today as it was scheduled and notified. Thank you.
Mr. Hunter.
Thank you, Mr. Vice Chair. We, of course, view that just a little bit differently. And I need to go through Mr. McDonald's objection kind of piecemeal, step by step, to address what I believe are some misunderstandings or errors that are in there. First one I want to address is what Mr. McDonald just got done talking about, which is the legal standard that we're working with here. On page 4 of his objection, and I don't know if we can switch to my laptop, Paul. See if we can get this up here. Oh, technology seems to work. Excellent. You'll notice that what is up on the screen is a highlighted, as soon as the Windows think of, there it is. What you'll notice up there is a highlighted passage from a decision from the Utah Supreme Court that says that the conservation statutes that Mr. McDonald was referring to don't wholly nullify the rule of capture. Establishing correlative rights is done with the law itself. Defining them, demarcating them, allocating them is done through a spacing order. But everyone has correlative rights by virtue of ownership of the minerals. The difference is wholly nullify. Mr. McDonald, in his motion, in his objection, argues for a complete nullification or an absolute rule of capture, unless you provide a spacing order, unless you get a spacing order. That's not the case. The second is a factual error that I think I need to address, and it comes up several times during the objection itself. I've got up on the screen here, as Mr. McDonald said, December 22nd, 2021 was our objection to the commingling. It was when it was filed with the state. And then the word he used later on in the objection was that for 7 months it lingered. It was lingering for 7 months, as if it just sat there doing nothing and nothing was being done. Well, it's true there was nothing on the record of the board, but there was a lot of activity, and I feel it's incumbent upon me to discuss what exactly that was and account for that 7 months to the board. On December 22nd, the objection was filed. On January 31st, 2022, FINLEY wrote me a letter asking what we should do to address this and resolve the issue. On February 8th, a big chunk of the oil and gas industry went down to NAPE. It's a big convention that a lot of the oil and gas industry goes to, kind of shuts down the place for a few weeks while people prepare for and then recover from the convention. February 22nd, 2 weeks later, FINLEY emailed me again to say, haven't heard back. What are we going to do with this commingling application? February 22nd, that same day, I replied, we'll have an answer for you by the end of the week. Friday, February 25th, 3 days later, I responded with a proposal for a voluntary 80-acre spacing unit equivalent. We want to get both sides of the river and the river itself into a voluntary arrangement that protects everyone's correlative rights, minimizes waste, maximizes recovery. Wednesday, March the 2nd, that proposal was rejected by FINLEY. Friday, March the 4th, 2 days later, I submitted a different proposal, this one on 40-acre spacing. One bank of the river, plus whatever piece of the river happened to be associated with that, and then if there was land on the other side, we'll have a separate 40-acre equivalent spacing for that. Also, in that communication, it was the first time I suggested that they consult specialized, experienced regulatory counsel. No response for 9 weeks. Friday, April 29th, nearly 2 months later, I sent a reminder to FINLEY saying, haven't heard back, with a stronger suggestion that they really should consult regulatory counsel for the intricacies and details and problems that we're going to have, not only with this commingling application here, but the problems that had been unearthed by our investigation into this commingling situation along the entire length of the river in this area that is under lease by my client, International Petroleum, from DFFSL, the state of Utah, sovereign state lands. Monday, May the 2nd, Finley promises to follow up. Friday, May the 6th, I remind them again, let's keep this front burner.
Excuse me, Mr. Hunter, I'm going to object to this. If you're going to give testimony, I want to have it sworn. This isn't part of the motion. It hasn't been submitted as an affidavit or anything like that.
Mr. Hunter, we understand. I think we'd ask you just to proceed, but let's move along a little more judiciously.
I'd be happy to move along if Mr. McDonald would stipulate to the fact that Finley was the one that would let this linger and not my client.
I'm not going to stipulate to that. You're giving factual testimony.
Then I believe I need to account for the 7 months that Mr. McDonald has accused us of wasting.
Okay, I think you've set the stage, but please proceed expeditiously.
Thank you, Mr. Chairman. On June 9th, Mr. McDonald filed this application, concluding approximately the 6 or 7 months of time between our objection and this hearing. The next thing I need to address is Mr. McDonald's argument that all we're talking about is spacing. That's not correct. The commingling applications have two problems. Number one, as I reiterated in all of the communications I had with Finley, they have a river problem. Their problem is they don't know where the river is. No one knows where the river is. That is a problem that is going to take place not only in this commingling application, but all up and down the river. And that needs to be addressed as a set, as a piece, because development is continuing there and will be continuing, I assume, for the foreseeable future. The course of the river and the edge of the river defines where a legal well location can be located under the siting rule, because this area is not spaced. If you don't know where the edges of the square or rhombus or irregular polygon that requires integral calculus to determine the area of, you don't know where the window is that you're allowed to put a well. And if you don't know where the window is, you don't know where the center is. If you don't know where the center is, you can't justify a deviation from the center of that for an approval for your APD. It all follows from where's the river. So that is the central problem with not only this commingling application, it's all along the river. And that's threshold. Because without a legal well, they really shouldn't be asking to commingle formations underneath an illegal well. We don't need to compound the error of putting a well where maybe it shouldn't be with putting formations together that aren't naturally connected in the first place. Because as I'm sure the geologist will testify, I believe I'll elicit this on cross, rocks are different at different depths. That's why we space formations. That's why we space intervals. We don't know, at least my client doesn't know, and the state doesn't know, EFFSL, they don't know what those rocks do here in this area south of the river.
Excuse me, Mr. Hunter. I do want to remind everybody we are discussing right now only the motion to continue and the justification for that, rather than the merits of the broader argument we're here today evidently to discuss. So could you really refocus on that motion to continue piece?
Absolutely.
For us, please. Thank you.
The second error that we have is Finley alleges that there's no evidence to support drainage is occurring behind its operated leaseholds. The commingling application needs to be redone, and that would take some time and may in fact not need to be done if we can work on a voluntary settlement, which, as I was explaining, we had 7 months that did nothing to do that. There was no substantive discussion before I got to the timeline when Fred and I had our first substantive discussion in June. I wasn't able to read that into the record, but that we haven't had substantive discussions about the issues between he and I. It was a lot of dead air silence from Finley and me trying to remind them, hey, let's do something. So rather than take up the board's time with a lot of argument, I think if Fred and I sat down with the state, the landowner, to figure out where the landowner's border was, that's going to eliminate a lot of problems with this. And that opportunity has not been taken advantage of by FINLEY. And so for purposes of judicial efficiency, for purposes of not having to redo the entire commingling application, I think it's in everyone's best interest if we take a moment. It could be 30 days, it could be 60 days, it could be 2 weeks. We just need to sit down and see what we can sort out with an indispensable party, state FFSL. They need to be in on this because at the end of the day, it's title to their property that's really the problem here. No one knows where the river begins and ends. And I'll turn it over to Fred.
Thank you, Mr. Hunter. Back to you, Mr. McDonald.
Just briefly, again, I appreciate Mr. Hunter's summaries and all that, but again, everything he is asking for, the title, where the riverbed is, this is all their burden to show in a spacing hearing, to show their rights to the production. If we get to the merits of this, you will find that the APDs were approved by the division at legal locations. And again, the whole issue here is not the commingling of production between the lower Green River and the upper Wasatch. It's the rights to the production. And that's done through a spacing hearing. And again, with that, there is no reason to continue this hearing dealing with commingling for these 3 wells. Thank you.
Thank you, Mr. McDonald. Division, any questions or comments on this issue? Again, pertinent to the motion to continue rather than the broader issue we're going to be discussing today.
No comments at this time.
Board, any questions on this issue? Yes. I'm suggesting we may want to deliberate on this one. So perhaps we should go into deliberations. Okay. We're off the record.
On the record.
My apologies. Back on the record. And I would entertain a motion related to the motion to continue.
So I would make a motion that we deny the motion to continue and continue with the hearing.
Second? All those in favor, say aye.
Aye.
Let the record show that was unanimous. And we did receive some late filed exhibits. Seeing as there were no objections currently to those exhibits, I will be signing those right now.
That would be the motion to accept a late filing of the International Petroleum exhibits. Is that correct?
That is correct.
Okay, I'd like it on the record that both the division and FINLEY do not have an objection to that, but we do reserve the opportunity to object to their relevance to this hearing
So
and admission
recorded.
into evidence.
And now I believe it is appropriate for me to turn the time back over to you, Mr. McDonald.
Thank you, Mr. Chairman. With me today as witnesses in this matter are Mr. Justin Arndt, Senior Landman, and appearing virtually is Mr. Shay Atkins, the Geology Manager. Shay, are you there?
Yes.
Or Paul, could we get him up there? There we go. All right, I would ask that they be sworn in at this time.
If you'd raise your right hand and I'll swear you in. You do solemnly swear the testimony about to give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I did.
Mr. Chairman, members of the board, the resumes of both witnesses were collectively submitted as Exhibit A in this matter. If asked, each will confirm the information reflected in the respective resumes is true and correct. Mr. Arndt will be a fact witness only. Mr. Atkins has been recognized by this board on many occasions as an expert in geology. Presuming the division and the protestant do not have any objection, we would ask that the board recognize Mr. Atkins again as an expert in geology for purposes of this cause.
The division has no objection to Mr. Atkins being recognized as an expert in this cause.
International has no objection to Mr. Atkins' recognition.
Board, any objections or concerns? Recognize the witness.
Thank you, and thank you to council. Also, Mr. Chairman, I'm going to confirm that it's acceptable that I will move for admission of our primary exhibits at the end of our presentation in chief, and if and as necessary, our rebuttal exhibits at the end of our rebuttal presentation.
Yes, that's acceptable.
Thank you. Members of the board, FINLEY is before you today seeking approval to commingle Lower Green River production with no more than 25 feet of Upper Wasatch production from 3 wells located in Section 12 of Township 9 South, Range 19 East in Uintah County. These 3 wells are the Lazy River 12-10-9-19, the 12-14-9-19, and the 12-15-9-19 wells. All 3 wells were legally drilled, directionally drilled, in accordance with Utah Administrative Code Rule R649-3-2, R649-3-10, and R649-3-11, and approved applications for permits to drill by the division. No protests of those applications were ever filed. All 3 wells were drilled upon FINLEY-operated leaseholds with common ownership in all depths. That's very important to keep in mind. Thus, there is no change in the production allocation occurring due to the commingling requested. Consequently, FINLEY filed for administrative commingling approval by the division in accordance with Utah Administrative Code R649-3-22. The applications were complete in all respects. True and correct copies of the rules R649-3-2, R649-3-10, R649-3-11, and R649-3-22 were collectively submitted as Exhibit B. Nevertheless, International Petroleum Limited Liability Company filed a protest of FINLEY's commingling applications with the stated basis that the wells were located, quote, rather close to the course, end quote, of the Green River and its state oil and gas and associated hydrocarbon leasehold covering the riverbed. No supporting technical justification was stated. However, as you will hear, the only well with producing intervals even remotely close to the river is the 12-14-9-19 well, and its productive intervals are more than 460 feet away from the riverbank per a survey of a licensed Utah surveyor. Because of the protest, under R649 3-22, the division could not administratively approve the applications. Instead, Finley was required to seek board approval through this request. As you will hear, there is no spacing currently covering these lands. Under the Cowling ruling, the rule of capture therefore applies. As you will further hear, the productive intervals to be commingled are in fact transitional zones, which, as to nearby areas, the board has recognized as one pool, and for which 10 and 20 acre well density has been authorized. In other words, one well per 10 acres, one well per 20 acres relating to drainage areas. As such, there's nothing to suggest that any drainage is occurring beyond the boundaries of the Finley's operated leaseholds, clearly with respect to the 12-10-9-19 and the 12-15-9-19 wells. There is no legal or technical requirement for Finley to seek spacing just to allow the commingling, let alone share any production with International Petroleum. In fact, but for the tiny portion of production from the upper Wasatch, this matter would have never come before the board. Bottom line, as I argued earlier, this is a commingling hearing, not a spacing hearing. Correlative rights are defined by spacing and are simply a party's opportunity to produce its just and equitable share of a pool. International Petroleum has so far failed to exercise that opportunity. It has never sought to seek spacing, nor has it attempted to secure an exception location approval of an APD for a well to diagonally drill to access the oil and gas within its leasehold. International Petroleum, in its response, claims that waste would occur if it's not allowed to share in this well. However, it's not waste when a party makes no effort to secure its own permit to drill or establish that its leasehold is otherwise being drained and seeking appropriate spacing. As a consequence, we ask the board to reject International Petroleum's protest and approve the commingling application as submitted. The board has jurisdiction over this matter pursuant to Utah Code annotated section 40-6-5, subparagraph 3C, and Utah Administrative Code R649 3-22. The applications, the commingling applications, were sent to all parties as required under R649 3-22, with the only protest being filed by International Petroleum. As evidenced by its response, International Petroleum received the request. The Division of Forestry, Fire, and State Lands, which administers sovereign lands such as the Green River riverbed, filed a letter in support of International Petroleum's response, but it was filed out of time and without leave from the board. We would therefore ask that it be stricken or at a minimum not be given any evidential credits because of that. Notice of this cause in this hearing was duly published in the Deseret News on July 1st, the Salt Lake Tribune on July 3rd, and the Uintah Basin Standard and the Vernal Express on July 6th. Other than International Petroleum and that letter, no other responses have been received. The division has elected not to file a staff memorandum in this cause. With that, I'll commence my examination of Mr. Arndt. Mr. Arndt, would you please state your name and business address for the record?
Yes, sir. Justin Arndt, address is 1308 Lake Street, Fort Worth, Texas, 76102. And I am a senior landman with some permitting responsibilities for Finley Resources.
All right. Would you please state for the record the corporate and bonding status of Finley?
Yes, sir. Finley is a Texas corporation with its principal place of business in Fort Worth, Texas. It is duly qualified to conduct business in Utah and is fully bonded with all relevant federal and state of Utah agencies.
All right, I'm now going to show you what has been marked as Exhibit C for purposes of this cause. It's shown on the PowerPoint. Was this exhibit prepared by you or Finley personnel with your review and input?
Yes, sir.
Would you please explain to the board and council and the petitioner, or the protestant, excuse me, what this represents?
Yes, sir. This is the regional locator map, and it's showing the location of the 3 wells at issue which are located in Lot 7 of Section 12, 9 South, 19 East. The 3 wells at issue are 40 miles southeast of Roosevelt, and also, as you see on the map, the Ouray National Wildlife Refuge is to the northeast.
All right. You stated that the 3 wells are in Lot 7. That's just the surface hole location for the 3 wells, and
Yes, sir.
And only one of the wells has any productive intervals in Lot 7?
That is correct.
Okay. Now I'm going to show you what have been marked as exhibits D, E, F, and G for purposes of this hearing. There's no PowerPoints or presentations on these since there's large documents and papers. Are these official business records of Finley and or public records that you obtained through the division's website?
Yes, sir.
Okay, I am going to start with Exhibit D. This is a 3-page exhibit. This is the one exhibit that we do have a PowerPoint. Starting with Exhibit D1, would you please explain what this shows?
Yes, sir. So Exhibit D1 is the well location plat for the Lazy River 1210-919. And it is located, it was a well directionally drilled from a surface location in Lot 7 to a productive intervals and a bottom hole location in the northwest southeast quarter of Section 12. The spud date was May 1st, 2021. The first date of production occurred on August 23rd, 2021.
And who prepared this plat?
Outlaw Surveying.
And is that a licensed Utah surveying company?
Yes, sir.
Turning your attention now, Exhibit D2. Please explain what this plat shows.
So this plat is for the Lazy River 1214-919 well, directionally drilled from the same pad, which is located Lot 7, to productive intervals and a bottom hole location, also in Lot 7. Spud date was May 7th, 2021. First date of production occurred August 20th, 2021. Lot 7 contains 34 acres, and I'd like to note the blue shaded area on the survey. That area represents the 460-foot buffer from the edge of the Green River bank.
And again, was this prepared by a Utah licensed surveyor?
Yes, sir. And one other thing to note here is that this bottom hole location was moved from adjacent leasehold to Finley's leasehold and was done so to remain in compliance with the 460-foot setback.
Right, now turning your attention to Exhibit D3, would you please explain to the board and council what this shows?
Yes, sir. This is the well plat for the Lazy River 1215-919 well, directionally drilled from the same pad in Lot 7 to productive intervals and a bottom hole location in the southwest-southeast quarter of Section 12. Spud date for this well was May 1st, 2021. First date of production occurred August 20th, 2021.
All right, would you please outline what is the current oil and gas ownership and leasehold status of these lands?
Yes, I can. The oil and gas underlying Lot 7, the northwest southeast quarter, and the southwest southeast quarter of Section 12 are owned in fee, and they are subject to 2 leases owned by Finley Production Company and Grassland Energy, LP, for which Finley is the duly designated operator. Ownership of the oil and gas and other interests in the leases, they are uniform to all depths.
All right, now turning your attention to Exhibit E that has been submitted in this, would you please explain what this is?
Yes, sir. This is showing that Section 12 is not spaced, and therefore the R64932 applies.
All right, let me back up again. What are these documents?
Okay, yes, sir. These are the APD approvals approved by the division.
Okay, and then go ahead and explain the significance of these applications.
Yep, the significance is to show that Section 12 is not spaced and that R64932 applies. And the 400-foot square drilling windows thereunder are depicted on Exhibit D, which are the well plats.
All right, when you went through the process, what occurred? These are directionally drilled wells, so what process did you go through?
We went through the process of applying for permits, and this was before my time with Finley, when these wells were permitted, I believe back in 2019. But we went to our standard permitting process and we do utilize a permitting agent to do that on our behalf.
All right, and since they're directionally drilled, did you comply with the requirements of R649 3-10 and R649 3-11?
Yes, sir.
And just to reiterate, these applications were approved as submitted by the division.
That is correct.
Okay, were there ever any protests filed to these, to your knowledge?
No, sir, not to my knowledge.
Okay, turning your attention now to Exhibit F. Please explain what these documents are and their significance.
Okay. Yes, sir. These are the approved sundry notices for the bottom hole locations. And they were submitted and sent as required under R649-322. And they were received by the division on December 7th, 2021. And I'm sorry, these are for the commingling, applications to commingle.
Right.
And FINLEY seeks to commingle the majority Lower Green River production with one set of perfs in the Upper Wasatch Formation. And Mr. Atkins will address that in further detail.
Okay, who did you send these sundry for the commingling applications to?
Yes, sir. The applications to commingle were sent to the offset owners, and International Petroleum was sent copies of the owner as an adjacent lease owner, and that's the state lease covering the bed of the Green River.
Okay, finally, turning your attention to Exhibit G. Would you please explain what this document is?
Yes, sir. That is a true and correct copy of the division's June 1st, 2022 letter advising of International Petroleum's unresolved protest and requirement to seek approval directly from the board as required under R649-322.
Did you ever receive, one of the documents included in there is the December 22nd, 2021 protest of International Petroleum. Did you ever receive that prior directly from International Petroleum, or when did you receive that?
No, sir. We never directly received a copy of the protest from International Petroleum. We received a copy on January 27th from the division when we met with them in their office to go over some drilling updates.
Right. Finally, I'd like to direct the board's attention to what has been marked as Exhibit Z, which is the proof of the receipt of the copy of the request mailed out by my office by both International Petroleum and Mr. Hunter as its counsel. With that, Mr. Chairman, that concludes my primary examination of Mr. Arndt. I do reserve the opportunity to call him back as a rebuttal witness as necessary.
Thank you. Mr. Hunter, do you have any questions for this witness?
I do. Thank you, Mr. Chairman. Mr. Arndt, at the beginning of your testimony, you said that you had some permitting responsibilities over at FINLEY.
Yes, sir. That is correct.
On your resume submitted as Exhibit A in this cause, you say you manage permit activity for development in the Uintah Basin. Is that correct?
Yes, sir.
Didn't qualify that, so I'm trying to figure out exactly how we're going to limit this knowledge. Is it because that you're relatively new, you just came back according to your resume in April of 2021, or is it that there are other people that manage the permitting activity with you?
I manage the permitting activity. However, we do utilize another company that actually submits the permits and all the sundries. So we do not file those until the well has been spud. After that point, then we handle it internally.
So if I understand you correctly, you supervise a third-party contractor who submits the sundries until the well is spud, but then after that, you are in charge of the sundry notices and other application or permit to drill modifications.
Our company is. There is actually another gentleman who handles those at that point with all the filings. So I would say I handle more the helping update the division and the BLM on the priority of permits and working with the third party and our internal operations group and our development team on when we're going to submit the permits and which permits we submit.
All right. So you don't necessarily have direct knowledge of all the facts that go into every single one of the sundry notices that were submitted.
No, sir, but I do review the APDs and sundries and have done so since my time here at FINLEY.
So essentially, people work under your supervision, you review their work, and then approve it for submission to the relevant regulatory agency.
Yes, sir.
So I may be asking you some questions, and if you don't know the answer personally, that's fine. Please say so. But if it is under your responsibility or control, I'd like you to speak up on that too.
Yes, sir.
All right, thank you. Let's turning to your exhibit, I believe is D2 that you just spoke about with Mr. McDonald. Yes, that's it there. Tell me about that blue zone that's on there. How did that come about? How did that get on that map?
So that was placed on the map by our surveyor, who is certified state of Utah. And when they prepared this plat and all three of these plats, they went on the ground to the location and surveyed the surface hole location, the bottom hole location of all three wells, and to ensure that we were 460 feet from the edge of the riverbank.
All right. Now, have you had a chance to review the exhibits that we submitted in this cause?
Yes, sir.
All right. I'd like to direct your attention to, bear with me a moment. Apologize for the slowness here. All right. This would be Exhibit 2.1, sundry notices and reports on the wells. That is for the Lazy River 12-14-9-19. Would you agree with that?
Yes, sir.
And that would be the well that comes closest to the Green River of the three wells that are the subject of this commingling request. Is that correct?
Yes, sir.
All right. And that would be the well that is awfully close to that blue zone in the previous exhibit. Would that be right? Would you agree with me?
Beyond the buffer.
But it comes the closest to the buffer of the three wells.
It does, yes, sir.
All right, thank you. This was the sundry notice for a well location change. I believe you testified on direct that this well had been moved. Is that right?
Yes, sir.
All right. I'm going to turn your attention to Exhibit 1-2. This is the 12-14-9-19 well, and direct your attention to the bottom of the exhibit. The received date, the date that it was received by the division is February 14th, 2019. Is that correct?
Yes, sir. That is the original.
I'm sorry, say that last part again.
That is the original plat.
All right. You can identify this as the original well location.
Yes, sir.
All right. Now, the drilling window that I've highlighted in yellow here, has that drilling window changed from the old application to the new application?
I believe it has, yes.
And I want to be clear you understand my question.
Yes, sir.
The drilling window, the location of the allowed area where you do not have to request an exception location or give notice to any of the adjacent landowners, has that physical location of the window moved? Just want to make sure you understand my question.
He's saying, did this
The
change
actual
from
window?
that? Yes.
Okay. Yes.
The window itself moved.
No, the bottom.
The bottom hole location moved. The window itself did not move.
I just want to make sure we're clear on that.
Yes, sir.
What changed between the original drilling application and the new one, the one that you actually drilled on, was only the bottom hole location, not the window itself.
Yes, sir. And it was done so to ensure that we were 460 foot from the adjacent leasehold.
So as your understanding, the implication from your response there is that that well location, the original one, was within the buffer zone of 460 feet.
The original location was, however, it was moved to go beyond the 460 foot buffer of the adjacent
understand.
leasehold
Yes.
onto FINLEY Resources leasehold.
And if you'd maintained this original well location and drilled on it, then you would have needed to notify and request an exception location for drilling within the 460-foot buffer. Isn't that correct?
Of the original bottom hole location, yes, sir.
And so one of the effects of moving the bottom hole location is you avoided having to send notice to the adjacent landowners of the location of the well. Isn't that correct?
No, sir. It was just to move the bottom hole location onto Finley Resources leasehold and ensure we were 460 foot from the buffer.
So it's your testimony that the original location is not on Finley leasehold?
We had to be 460 feet or beyond.
I just want to make sure I'm understanding you correctly and that the board understands you as well. Did you file an application for permit to drill on a bottom hole location that you did not have ownership of the minerals for?
No, sir. We had
All right.
ownership of the minerals.
Okay, so the bottom hole location in your original application was owned by Finley,
Yes, sir. That's correct.
and the bottom hole location on your subsequent change, where you actually drilled the well, is also owned by Finley.
Correct.
The only difference between the bottom hole location as originally permitted and the new bottom hole location is that it's outside the 460-foot alleged setback from the Green River.
Correct.
And the consequence of moving the bottom hole location from inside the 460-foot setback to outside the 460-foot setback is you did not have to notice the state or my client that the well was going in within the tolerance zone within the 460-foot setback. You didn't have to tell them where the APD was being approved.
Per the rule, no, but that wasn't the reason why we did it.
Do you know why the bottom hole was moved?
Yes, sir. To ensure we were 460 foot from adjacent leasehold.
It wasn't a geological factor?
He's not qualified. He's not qualified for that. Ask the geologist.
I'll rephrase. Let me lay some foundation on that. Mr. Arndt, you manage the permitting process.
I am not a manager.
You're not a manager. Are you present in meetings where these changes are discussed with, say, an interdisciplinary team of petroleum engineers, geologists, management, economic types? Are you present in those meetings?
I am, however, when this decision was made, I had just joined the company, so I was not.
All right. So you don't have any direct knowledge of the exact reason why that bottom hole location was moved?
No, sir, other than it was to ensure we were 460 foot from the adjacent leasehold.
I just remember you're under oath. I just want to make sure that we're all clear on exactly what you're testifying to.
Asked and answered. Asked and answered.
Could I just remind council that we are here to discuss the request for agency action related to commingling? So if you could move on unless this is pertinent to that topic.
Mr. Chairman, what we're trying to establish is that they're not sure where the river is, and this movement of the well was to get outside the river's edge.
Objection. That's a conclusion that he did not state. They did the location based on the survey that was shown on Exhibit D2. That was what his testimony was, that they received that from a licensed Utah surveyor.
Sustained.
Let's go back to that river then. Let's talk about the survey directly then. Did you engage Mr. Pence of Outlaw Engineering to conduct that survey?
No, sir, I did not.
All right. Do you know who engaged him?
No, sir, I do not recall. I was not part of those discussions when that occurred.
All right. And Mr. Pence, you don't know what instructions Mr. Pence was given in order as far as going out to find out what exactly was out there?
Again, I would just point to my understanding is it was to ensure the bottom hole location was 460 or beyond from the adjacent leasehold.
It's your understanding that you ordered the survey, your company ordered the survey to establish the boundary of the Green River. Isn't that correct?
To establish the adjacent leasehold, 460 foot from the adjacent leasehold. Yes, sir.
Do you know what the boundary of the Green River is?
No, sir. I would just point to that we have a licensed Utah surveyor that went out on the ground and surveyed and certified it. And
As part of your preparation and decision-making this, did you review the mineral leasehold that I referred to in our response to the commingling application?
After the objection to the applications came up, I did, yes, sir, but
All right.
not before that.
Do you recall the legal description that was on the mineral lease from the state?
No, sir, not from memory.
All right. If I showed you a copy of the lease, would that help refresh your memory?
Yes, sir.
All right. Well, let me put up a copy of the lease. I'm showing you for the record, Mr. McDonald, this would be the hard copy if you'd like to review that. I'm showing on the screen, I'm showing on the screen a copy of mineral lease number 200000136, Utah state lease for oil, gas, and associated hydrocarbons, recorded in Uintah County, dated August 14th, 2015, recorded on September 4th, 2015. Can you make out the writing on there? Do I need to enlarge that maybe?
No, sir, I can read it.
All right, great. I'm going to scroll down to the underneath the witnesseth paragraph to the legal descriptions. I'm looking at the yellow highlights. Township 9 South, Range 19 East, SLM, Section 12, bed of the Green River. Is that what I'm reading that correctly?
Yes, sir.
All right. Does that tell you where the Green River is or the bed of the Green River?
No, sir.
All right. So as a matter of public record, there is no legal description with meets and bounds that tells you the edge.
Can I ask you the relevance of this? We've already testified, Mr. Arndt's already testified that they're relying on a licensed Utah surveyor's plat showing 460 feet from the river. So that's not the bed of the river, that's the edge of the river.
The commingling application is predicated on being outside the 460 foot. The edge of the river is the boundary line, the leasehold line, where the siting rule says you need to be far enough away from before you can have a legal location. If they don't know where the edge of the river is, they don't know where the bed is. If they don't know where the bed is, they don't know if they're far enough away from the bed.
It's still irrelevant to the standpoint of that is, if they want to challenge the legality of the APD, that should be done through a separate hearing than this commingling hearing. I keep coming back to the relevance.
And as I noted during my cross-examination of Mr. Arndt, the movement of the bottom hole location avoided notice to the state and to my client. We didn't have the opportunity to protest the APD.
So Mr. Hunter, I feel you've established that that movement occurred. I don't know if we should go into hypothetical motivations for that at this time. I'd ask you to proceed, please.
Then I will direct Mr. Ard's attention to Exhibit 6 of the defense exhibits, the respondent exhibits. You have that up on the screen, or yeah, you have that up on the screen here. And you were able to examine this before the hearing, is that correct?
Yes, sir, I did briefly examine it.
Okay. Had you ever seen that before you examined it as part of this cause?
Yes, sir, I have.
And what was the context of your viewing of this in prior times?
I believe it was after I started. I hadn't worked Utah before, so just trying to get a better understanding of different environmental factors. And so that's the in the vein that I had read it through.
Okay. And did you do a detailed reading of it page by page, or just more familiarize yourself with its contents?
Just more familiarize myself. Yes,
Sure. Do you read the introduction?
Yes, sir. And this was last year, so I can't.
Oh, sure.
No.
Hey, if I put it up on the screen for you, would it help or jog your memory a little bit?
Sure.
All
That'd
right,
be great.
great.
Yeah.
I'll go ahead and do that then. But you do recognize, is it your understanding then that this is a sort of controlling document or a position paper for the state of Utah Forestry Firelands to help manage their resources?
To the best of my knowledge, yes.
And so if there were, say, a conflict or a question or a multiple mineral use issue or an environmental issue, they would consult this document first and foremost to determine a policy direction.
He can't answer that question. That's for the witness from the agency.
Sustained.
Let me go down then to the introduction, which you said you had read previously, and direct your attention to the very last sentence of the introduction. I'm going to go ahead and read that out loud. Sorry, the second to last sentence. So I'm going to go ahead and read that out loud, and you tell me if I get this right. Because knowing where the ordinary high water mark was located at statehood is challenging, and because the ordinary high water mark has not been mapped continuously along the Green and Colorado rivers, a case-by-case demarcation of the ordinary high water mark may be undertaken as part of a permit authorization process. Sovereign lands of the Colorado and Green River shown in Figure 1.
Objection, Mr. Chairman. Again, I go to relevance. You know, this is a state document saying what it wants. If the protestant wants to establish that the state's location of the river is at a certain place, he can do it through a spacing hearing. And again, Mr. Arndt's testimony dealt with a surveyed plat showing the 460 feet from the riverbank by a surveyor.
Sustained. Mr. Hunter, please proceed and try and stay focused on the issue at hand, which is the request for agency action related to commingling.
Mr. Chairman, and again, perhaps I do need to do a better job of explaining the relevance. The relevance to the commingling application is that it's all entirely predicated on the well being located in a legally permissible spot. That legally permissible spot is based on the siting rule. The siting rule depends entirely on being able to locate the edges of the property. The state, through this document, has stated that the edge of the river is the ordinary high water mark, not, as Mr. Arndt has testified, a survey.
Mr. Chairman, if Mr. Hunter wants to make that point, then he can do it through his own witnesses. I mean, I don't know why Mr. Arndt's being asked about a state document other than he reviewed it.
Mr. Arndt testified that he reviewed it. He should have knowledge of its contents. I can cross-examine him on it.
Please proceed, Mr. Hunter, but do try to stay focused on the actual issue, the request for agency action.
Yes, Mr.
And
Chairman.
I don't know if this witness is qualified as a geomorphologist who can comment on a surveyor finding the normal high water mark. So your questioning may not really lead anywhere in that direction.
Very well, Mr. Chairman. Thank you. I'll turn your attention then to your exhibit, petitioner exhibits. I'll locate the number here. I believe we're looking at Exhibit F. Should be up on the screen now. Who is Josh Morgan?
Yes, sir. He files many of our sundries, and both with the division and with the BLM.
Is he supervised by you, or do you supervise him? Or
No, sir. No, sir.
Just you're a colleague?
Yes, sir.
All right. He wrote on this application, allocation should never be necessary, but if it is ever necessary, we'll base it on individual formation production percentages developed during the initial testing of the well. Do you know what that means?
That they would test the application. Is that what you're talking about?
Well, I'm just asking
language?
I'm asking if in your position as a permit manager, even though you didn't personally work on this, do you know what that sentence means?
Yes, sir. That they were applying to commingle the Wasatch and the Green River.
I'm going to focus on that very first clause there. Allocation should never be necessary. Why is that?
Because there's uniform ownership as to all depths.
Let's see, and you testified to that on direct that it's uniform. The mineral ownership is the same both in the Wasatch and in the Green River.
Yes, sir. That is correct.
This first page of the exhibit is for the 12-10-9-19. If I told you that the same sentence appeared in the other two wells are subject to, do you have any basis to dispute that with me? We can just move on.
No, sir.
All right. Are you, and you testified, or you heard Mr. McDonald in his opening give several citations to regulations regarding commingling Are you familiar with regulation R 639-3-22?
Yes, sir. I don't think I could recite it from memory, but
If I showed it to you on the screen, would that help?
that
All right,
definitely
we'll
helps.
do that then. Mr. McDonald's Exhibit B, I'm looking at paragraph 2. I'm going to read that and you tell me if I get this right. If oil or gas is to be produced from 2 or more pools open to each other through the same string of casings so that commingling will take place, the application must also be accompanied by a description of the method used to account for and to allocate production from each pool so commingled. Did I get that right?
Yes, sir. That's how it reads.
All right. I'm looking for an exception to that rule that says you don't have to do it if there's uniform ownership. Is that, I don't see it in there. Do you see it?
Objection. It says a description of the method used to account. And I believe you were the one that showed it on there that said that the allocation was not necessary. So that describes the method.
Mr. Hunter, please respond to that.
Happily. There is the method. There's an and in there. I paused to make sure everybody got that. There's an and in there. There's 2 requirements. One is to provide a description, which they did. The second is to actually allocate, which, according to the sentence that I read from their sundry, they are not going to do.
And it should be logical that if it's uniform ownership, there should be no difference in the allocation.
Mr. McDonald may be correct that it's logical, but according to the regulation, it's not legal, which means the commingling application is deficient.
Please, let's move on to the issue at hand.
Mr. Borden, that is the issue at hand. The commingling application is deficient without following Rule 649-3-22. I have no further questions for this witness.
Mr. McDonald, back to you.
I have no redirect unless the division had any questions.
Division.
No questions for this witness, Your Honor. Or Chairman.
Board, any questions for this witness? Seeing none, I guess the time is, oh, we have one. I'm sorry. Mr. Moon.
Yes, sir.
So plans to space this area. Right now you're delineating the structures. What are your plans as far as spacing?
Yes, sir. We were just drilling these wells under statewide spacing.
Let me redirect that. You were doing it under the well siting rule.
Yes, sir.
Okay.
Correct. Yep.
And I guess the same question for international plans to request spacing for this area.
As I was noting in our discussion on the objection earlier, our focus has been on determining a voluntary spacing and pooling situation to avoid the thorny issues of where's the ordinary high water mark at statehood.
Wouldn't you need to know what your where you figure that is? I mean, have you had a survey done to form that?
That would be part of the discussion, voluntary discussion that we never had the opportunity to have with FINLEY, that the expense, time, and effort in resolving the conflict between a modern survey in 2022 or 2021, whenever the survey was actually accomplished, and the legal implications of the ordinary high water mark, accretion, reliction, avulsion, all the things that go into riparian title law. It might be better for all concerned, and in my view and in my client's view, would be better for all concerned to come to an agreement among the parties that doesn't change title to the land, because we don't know what that is, but does allocate production and expenses for achieving that production in an equitable manner that relatively reflects what the parties believe the ownership might be. If this is going to be adversarial, the state's under an obligation to its title, and we're going all the way, and we're coming with them. But it might be better for all concerned to have an agreement where those thorny questions can be avoided.
Any other questions from the board?
I
One more.
Um,
Ms. Garrison.
Mr. Hunter, this goes to the oil and gas lease. And the
Yes,
only
ma'am.
question I have is, This lease says specifically 918.76 acres more or less.
Yes, ma'am.
Did your clients have any idea how those are allocated among all of these sections? How did you come up with 918.76 acres?
We did not. There was about 918.76 acres in this parcel.
Thank you.
We, okay, let's go off the record for hopefully just 5 minutes.
Next to the IT guy when it froze. So, yeah.
System check, system check.
Check.
Thank you. Mr. Chairman, it looks like the network connectivity issue has recovered. If you'd like to go back on the record, we show systems are green.
All right, back on the record, I also have one follow-up question for you, Mr. Hunter. That state record you referred to, which shows the boundaries of
System check, system check.
Check.
Thank you, Mr. Chairman. I am going to initiate a phone call into our enterprise IT services group and see if I can get a perspective of what's going on. Hopefully it will stay.
advisable to take our lunch break now a little early to maybe resolve this issue?
Yes, if we could go to lunch, that would give me time to have those technical contact discussions. We do not know if it's internal to our state network or external, but
Okay, we are off the record.
we are currently off the record. If you'd like to return, our recorders do show they are working for the moment.
We will reconvene at 1 o'clock. Thank you.
Always a combination where you have just everything happen. You know, I mean, why not? Yeah, why not? If we're gonna do one, let's do it.
but they're looking into it.
Thank you.
Welcome.
And I'm afraid I do have one last question.
I'm looking forward to it.
Oh, not for you.
Oh, not for me?
If I may go back to Finley, yes.
Yes, sir.
Do you know when the surveyor did go out to survey that 460-foot setback, did they just go to the edge of the river as it was flowing on the day they did that, or did they go to the cut bank of the river or some other marker of the normal high water mark to mark that off?
I couldn't tell you. I do not have knowledge about that. Sorry about that.
No worries. Thank you very much.
Yes, sir.
Back to you, I guess, Mr. McDonald.
Thank you, Mr. Chairman. Now I'm going to commence my examination of Mr. Atkins, who's appearing virtually. Mr. Atkins, would you please state your name and business address for the record?
My name is Shay Atkins, business address at 1308 Lake Street in Fort Worth, Texas, 76102.
And what's your current position with Finley?
My position is geology manager with supervision over this area.
All right, I'm going to turn your attention to what has been marked as Exhibit H. It's appearing on the PowerPoint. Do you have that in front of you, or can you see it okay?
Yes, sir.
Was that prepared by you or Finley personnel with your review and input?
Yes, it was.
Okay, could you please explain the significance of this exhibit and give a little more background on the two formations that your Finley is asking to commingle here?
Yes, sir. So what you're looking at is a cross section of the 3 wells that we've been discussing today, with the gamma ray signature highlighted on the left side of the depth track for each well with the yellow, gray, black patterns. You can see these are the 3 wells that we've been discussing with this is zoomed in to the TD section, the total depth, the bottom of the well section of each of the 3 wells, given that that's really what we're discussing here today is commingling these 2 formations at the TD of the well. So you can see the red line represents our interpretation of the Wasatch Formation, the top of the Wasatch Formation, also known as the base of the Lower Green River Formation, as you can see on the right side. And so this is a zoom in. This doesn't depict everything in the well, but since we're only focused on the Wasatch Formation, and so the red tick marks, the red line or the red marks on the left side of each log represent individual perforation clusters. And so these are the places that we perforate the production casing in order to allow access to the formation to produce the well. And so as you can see on each of these 3 wells, there is one individual set of perforation clusters in the Wasatch Formation, and that's it. Everything else, every other perforation cluster, everything else completed in these wells is in the Lower Green River Formation. And so just to put that into perspective, that represents 1.6% of the perforations of each well. And so really all we're discussing here today is 1.6% of the completion interval of each of these wells.
Can you now address, is there any distinguishing factors between the Lower Green River and the Wasatch here that would change drainage or something other, that would distinguish between the two? Are they transition formations, et cetera, something like that? Would you address that to the board?
Sure. Yes, sir. This is a transitional zone between the upper part of the Wasatch into the Lower Green River Formation, as I've testified before, and I'm testifying here today. And we're also talking about the upper 25 feet being the transition zone between that Wasatch into the Lower Green River. And these also represent a common source of supply through this transition zone with no differences in permeability, pressure, or porosity of these formations at these depths. And so being in that transition and a common source of supply, these are treated equally in our eyes.
Okay, based on your experience and the testimony you've just given there, have you formed an opinion as to is there any material differences between the transitional zones that would cause a different drainage pattern or anything like that?
No, sir. As stated, being no difference in the formations themselves of this and through this transition zone, it's my geologic opinion that drainage would not occur outside of FINLEY operated leasehold, and that there's no differences between the two perforated intervals in these wells.
All right, thank you. That concludes my examination of Mr. Atkins.
Mr. Hunter, do you have any questions for this witness?
I do. Thank you, Mr. Chairman. Mr. Atkins, you started off by saying that the interval definitions were, quote, your interpretation or our interpretation of those intervals. Did I understand you correctly?
Yes, sir.
All right. So why are we commingling these things if under your definitions, they're basically the same formation?
This is my interpretation of those formations.
So in your geologic opinion, they're different enough to warrant a commingling request?
Yes, sir. I've identified these as being the Lower Green River and the Wasatch Formation across the transitional boundary, and therefore by law, we're required to file a commingle.
So under the law, you're required to treat them differently, even though they're mostly the same in terms of, you know, the types of rocks, pressure, that kind of stuff.
Yes, sir. And I've also previously testified on multiple occasions that they also represent a common source of supply and have provided geologic and reservoir engineering data to support that.
Because that's in the transitional zone. Is that correct?
That's correct.
By implication, that means that you go a little farther down and you're no longer in a transitional zone, you're in a different zone. Is that right?
We're only talking about the transitional zone here today in the upper 25 feet of these wells.
That's correct. You've only perforated that transitional zone, but at some point it stops being transitional. Do I understand that correctly?
Well, there's other formations below.
That are also in the Wasatch?
There are other parts of the Wasatch Formation. There's other formations below the Wasatch. The focus here today is the transitional boundary between the upper Wasatch and the lower Green River.
And there's one perforation accounting for, and correct me if my notes are wrong here, but it's 1.6% of the number of perforations. Is that correct?
That's correct.
What about, and I believe Mr. McDonald in his opening statement, I want to make sure I get this right. In his opening, he stated that the Wasatch production represented, quote, a tiny portion of production. Do you recall him saying that?
Yes, sir.
Now, was Mr. McDonald speaking, and is it your testimony that it's a tiny portion of the volume of oil and gas produced, or just a tiny number of perforations from which oil and gas are produced?
It could be both. According to my slide I've presented, it would be the tiny portion of the number of perforations shown, or the number of perforations that exist.
And correct me again if I misheard you. You said it would be both. And so yes on the number of perforations, but is that also a yes on the volume of oil and gas produced?
I said it could be both. And according to the slide that we're looking at right now, shows that it's the small portion of perforations.
And I just want to make absolutely clear I'm understanding this. You are not testifying as to the volume. You are not giving any information as to the volume of oil and gas produced from that perforation. Is that correct?
Not currently on this particular slide. That volume and drainage radius typically is related to spacing orders, and currently we're looking at a very small percentage of the well completed with my geologic interpretation and my geologic opinion that we are not draining outside of our owned acreage.
So you're saying that your opinion is that there's no drainage farther than that, but you are not able to testify to the underlying facts, or not willing to testify to the underlying facts? I'm giving my opinion, my professional geologic opinion, and I'm also referring back to the slide that we are looking at currently on the screen and the data that has been presented thus far. You swore an oath a little earlier. Do you remember doing that for the court reporter?
Yes,
You
sir.
promised to tell the truth, the whole truth, and nothing but the truth. Remember that part?
That's right. Many times.
All right. Okay. So when I ask you this question, please remember that. Do you have personal knowledge of how much oil is being drained from those perforations?
Yes, sir.
If I ask you the question, how much oil is being drained from the Wasatch Formation, from those perforations, are you going to answer my question?
Yes, sir.
Mr. Atkins, how much oil is being drained from those perforations in the Wasatch Formation? Let's start with the 1214-9-19 well.
Very little.
Mr. Atkins, do you or did you not just testify that there's no drainage outside the legal area, the lease line of FINLEY?
Yes, sir, I did.
And your testimony is that very little is sufficiently precise and sufficiently accurate enough to determine drainage from a well.
Can I please confer with counsel for one moment?
No objection.
Yes, you may. Yeah.
I'm back.
We're back on the record. Please proceed.
Thank you, Mr. Chairman. Do you need me to repeat the question? Thank you, Mr. Atkins. Do you need me to repeat the question, or do you remember what I asked?
I remember what you asked, and I'd like to ask Mr. McDonald to please go to a rebuttal exhibit K that we've previously prepared.
I have been provided this exhibit, and Mr. McDonald, were you going to put it up on the screen, or are we just going to hand it up? Okay, we'll wait for Mr. McDonald to get that on the screen, and then we'll resume.
Look at that. Just like a monkey.
Please let me know when you're ready.
I believe we see it on the screen now, and you remember the question, so please go ahead and answer at your convenience.
Yeah, so let me go through rebuttal exhibit K, please. There's a lot going on here, and there's a lot of colors and things. So what you're looking at is a process log, is a detailed log that FINLEY asked a third-party petrophysics and analysis company to do on the Lazy River 12-15-9.
Let me stop you just for a second, Mr. Atkins. Can I stop you just for a second and ask you about that? This is a third-party company. So was this exhibit prepared under your direction and supervision?
Yes, it was.
And do you have personal knowledge of the facts underlying the preparation of this exhibit?
I do, and I also have the reputation of the company shown in the top left of the screen as a global.
I'm not asking about Mr. Atkins. I don't need to know the reputation of the company. I'm asking about your personal knowledge. Do you have personal knowledge of the facts underlying the creation of the exhibit?
Yes, sir, I do.
Mr. Atkins, are you qualified to analyze petrophysical data according to your resume, or do you have those qualifications? You've been qualified as an expert witness in geology. Are you able, and does your education permit you the proper understanding to analyze not only the underlying facts, but the conclusions of apparently new tech?
Yes, sir. Well, understanding the original oil in place in the rock falls under the realm of geologic expert. And so I'm here today to testify on to the volume of original oil in place of this rock in this area.
I appreciate you indulging in that brief voir dire. Please continue.
And so, as you can see, there's a lot of colors and things going on, and there's a lot of detail in the analysis that NewTek does. NewTek is a very well-known petrophysics and analysis company. They do work in many basins around the world with all the major U.S. and global operators. And so, if you look at the column towards the right, excuse me, with the red outline, the red oval, this column represents their interpretation, their calculation of original oil in place of the Lazy River 12-15-9-19. And the reason why—
Can I stop you again, Mr. Atkins, just for a moment?
Yes, sir.
Can I stop you again? If you'll recall, my original line of questioning was for the 12-14-9-19.
Yes, sir.
Do we have a chart for that?
I'm in the process of answering your question.
Well, my question went to 12-14, so maybe we should—
Mr. Chairman, let Mr. Atkins answer the question and he'll tie it to the relevance of the
He's
other
not
wells.
answering my question. I asked about the 12-14. He's showing me a chart for 12-15. Can we bring up that one?
He's trying, this is analogy to what he has here.
Well,
That's
then
what
he
I'm
could
trying
have
to
brought
tell
this
you.
up on direct where Mr. McDonald can control the flow of information. This is my examination.
I believe these wells are fairly close together. The geology probably has some lateral continuity. I'd be interested to hear about this one. And
I am
perhaps
too,
the other one.
Mr. If I can just proffer what my line of questioning here is. One of the issues here is that the 12-14 gets real close to the river. The other two wells do not. The reason, and Mr. McDonald and I had a conversation in the hallway, the reason that IPLLC is not going to stipulate to the fact that we're not too concerned about the easterly wells is because if we do have to go to spacing, and this is getting awfully close to what you might hear at a spacing hearing, is that communication and interference between the wells is critical to find out whether or not you've got the right distance between the borers. And so if we're going to do that now, I'd really like to know. My question started with the 14, which is where we have our greatest concerns. If he's starting with the 15 and we're going to do a circle around, I spent a lot of time just a little while ago being told this was not a spacing hearing. Are we going there? Because
You're
if
the
we
one
are,
that's bringing it there. You're the one that asked the question.
So let's not chase our tails here. Could we just have the witness describe this and then let's deal with 14 next? Just let's get this thing completed, maybe without interruption. Let him describe this plot. I think we're all interested in that. And then I think you should be asking about 14 as well.
Thank you, Mr. Chairman. Thank you, Mr. Chairman.
Thank you. Please proceed.
So as I was saying, the Lazy River 12-15-9-19 is the only well of the three on the pad that we have open hole triple combo logs on, which are the logs, the open hole logs sufficient to do this type of analysis. What you do geologically is you take the data that you have and you correlate to known formations. And you can see that I did that on the previous slide with the gamma ray correlation to show similar intervals. Okay. This is one well spot away. This is part of the protest that you're currently protesting. And so if you look at the column towards the right with the red outline, you can see the green highlighted, and that is NewTek's interpretation and analysis of original oil in place in the Lazy River 12-15 well. And this correlates back to the Lazy River 12-15 well. The only logs that I have on the Lazy River 12-15 well is the gamma ray log that I've already presented to you. And so if you look down underneath all the colors in the log, you can see a summation of the analysis from NewTek, being the cumulative original oil in place for the producing interval of this well, the Lazy River 12-15, equating to 134,437,000 barrels of oil per section. Of that, the Wasatch interval represents 4.7, just over 4.7 million barrels of oil per section, which equates to 3.5% of the total original oil in place in the section. If you look further down to the chart, you can see the calculation that takes at the top row the original oil in place as presented from the NewTek log analysis, the 34 acres, the size of the drilling unit for the Lazy River 1214 well that you have been asking about. 34 acres equals 7,141,966 barrels of oil. If you skip down one to the recovery per well at 130,000, this is Finley's estimate of the expected recovery of this well going into the drilling process before putting our own capital on the line to take the risk to drill this well. And so if you take that expected recovery and this calculated oil in place from a reputable company known worldwide, that equates to a recovery factor of just 1.8%. And now it seems very unreasonable to me that 1.8% of the recovery of the amount of original oil in place at 34 acres would drain outside of the Finley owned acreage. And furthermore, if you apply the same calculation to only the Wasatch Formation, which is all we're really here discussing, the Wasatch Formation, you would be draining 1.8% of the 3.5% original oil in place calculated. And so those numbers seem very unreasonable to me to be causing any harm outside of the 34-acre drilling unit that Finley has drilled.
Does that conclude your answer?
Yes, sir.
All right. Can we talk about the recovery factor?
Towards the bottom of the exhibit, that equates to 7,141,966 barrels of oil, original oil in place, prior to us drilling the well. You skip down to the bottom and say recovery per well. That is an input, that is our estimate of what we expected to recover from this well prior to putting our own capital on the line and drilling the well. And so if you take that recovery percentage, 130,000 divided by 7,141,966, that equals 1.8% of the oil would be recovered at those estimates based on their calculation, a third-party calculation of this well.
And so the 130,000 is the numerator and 7.1 million is the denominator. Do I have that understanding correctly?
Well, yes. Let me make sure I've got I don't want to say it wrong. One moment.
Sure. No, please take your time. I had to hear it twice to understand it myself. Please, take your time.
That's correct.
All right. And the 130,000 number is a number that your internal management or your internal company decided on, not NewTek. NewTek didn't provide that number.
That's correct.
All right. And how did you arrive at 130,000?
How did I personally arrive at 130,000?
Yes, sir.
Well, through our internal analysis of expected recovery from wells in this area based on the geologic data in the area.
Okay.
Plus,
and so this is your. I apologize. Please continue.
Yeah. So it was our own data based on past experience and geologic data in the area.
All right. And from the number 130,000 that your internal proprietary system came up with, combined with the NewTek data, NewTek analysis of 7.14, you come up with a recovery factor of 1.8%.
Yes, sir.
And from that 1.8%, you conclude that there is no drainage outside of Finley's lease lines.
Yes, sir. And that's my geologic interpretation. And that's also seems very it seems unreasonable based on these numbers.
All right. So if that number at the bottom, the recovery per well, went up, that could affect the recovery factor and your analysis of how much drainage there was. Do I have that correct?
That's right. So if we double that, I almost included this, but let's say we double that to 260,000, that becomes 3.6% recovery, 3.6% of 3.5% of the original oil in place. And so the only thing that we're concerned here with is the 3.5% of total calculated original oil in place. Everything else is irrelevant. And so we're talking about 1.8% of 3.5%, which I could do the math on that real quick, but it's a pretty low number.
Sure. Yeah. A percent of a percent gets pretty small from the Wasatch. From the Wasatch, absolutely. But conversely, and what's underlying your analysis is that recovery factor translates into a linear distance, or maybe in your internal models, a square acreage, let's say, of expected area of drainage. Do I have that correct?
It could, and you're getting into some reservoir engineering questions, which are not really in the purview of this commingling, but yes, that is the direction that you could go with that information.
Absolutely. I'm just a little confused because in order to support the statement, your expert opinion, that there's no drainage outside the lease, you're going to need to come up with a number, whether it's an acreage number of area or a distance number in linear feet from
Objection.
the world.
Mr. Atkins testified from a geologic perspective what his opinion is.
And I have the right to examine the facts on which he relied on.
Do I say he's
Sustained.
For the record, I need to make a proffer on that. I understand I'm not to continue to question the witness in this manner, but I need to make a proffer of where this is going. His testimony is, in his expert opinion, that there is insufficient evidence to support a claim of drainage outside the lease boundaries. I have been instructed by the chair that it's perhaps outside the relevancy to discuss the lease boundaries. However, Mr. Atkins' testimony has brought that into sharp relief. He has testified there's no drainage beyond the boundaries, which again brings the placement of the boundaries back into question. His statement, his expert opinion, that there is a linear distance of some kind that he knows, which is less than the purported distance from the wellbore to the edge of the property, which is the river, which is demarcated by the ordinary high water mark, which they do not know. Mr. Borden asked that question. Then how does he support the conclusion with facts on the record on which the board can base a decision that the distance, whether acreage wise or linear wise, is less than lot 7?
And the answer to that is he provided his expert opinion from a geologic standpoint. If Mr. Hunter has something to rebut that, he can do it in a spacing hearing.
To be honest, I believe we've gotten off track here. I want to remind everybody we are actually, the request for agency action is about commingling. I feel like we are starting to move as if we're doing a spacing order here. I want to get us back on track to the commingling issues and the issues that are germane for the board's understanding of that topic, if I could.
Just as a reminder and connected to my proffer, Mr. McDonald elicited the testimony from his geologic expert.
And he gave his expert opinion on that. If you have something to refute it, that's fine. But I agree with the chairman that Mr. Atkins' testimony went to the fact that there is no distinguishing factors between the Upper Green River and the Wasatch here that would distinguish a drainage issue.
And I am not being permitted to examine him on the underlying facts that formed his opinion. I just want that noted for the record on appeal.
Thank you for clarifying that. Please proceed.
Thank you, Mr. Chairman. You testified on direct that the Wasatch and the Uintah Butte are considered, in your company's view and per your prior testimony before the board, a common source of supply. Is that correct?
That's correct.
All right. And you're familiar with the rule governing commingling that Mr. McDonald put into the record as Exhibit B?
I have some knowledge. I'm not an expert on that matter.
If I put it up on the screen, are you able to see the screen that as we're projecting it? Paul, do you have that capability?
Mr. Hunter, just ask him the question you want to ask.
Well, I did ask him the question. He said he doesn't know the exact details, and I'm going to help
About the
him.
rule, but what are you trying to get at?
I'm going to ask him if he knows what the threshold requirement is for commingling. Do you know what the threshold requirement is for commingling?
I do not know. Pardon me. I do not know offhand.
Okay.
The rule speaks for itself.
I'm not able to recite the rule.
If I told you that Rule 649-3-22, subsection 2 starts, if oil or gas is to be produced from 2 or more pools open to each other through the same string or casing, so that commingling will take place, that's the predicate for the rule, is that there has to be 2 or more pools. You're going to disagree with me that that's the rule?
No, sir. I'm going to defer to my counsel that is the accurate rule.
That's a pregnant pause, but
That's for
can
you,
we
Fred. He's
continue?
deferring to your counsel. He's deferring to counsel.
I was waiting for you.
He was deferring to you. I mean, I
The
can
rule
answer
speaks
him.
for itself.
Okay. I hear no objection to my recitation of that rule. But you just testified a second ago that it's 2 or more pools. I'm sorry, Mr. Atkins, are you texting? Were you just texting just now?
Am I interrupting your
No, I
question?
was just wondering who you're communicating with. I can't see you, obviously, because you're not in the courtroom, but were you communicating with someone outside
Well,
of the
sir,
room?
I actually have a job also outside of this hearing. So, we have active drilling rigs and things that I'm trying to keep up with as well. So I'm paying attention and I'm reading my notes and ready for your question. Please ask it.
As chairman, I do want to remind everybody, let's try and stay civil. And, let's try and stick with the issues, not talk over each other. Let's just act like adults. Thank you.
Mr. Atkins.
Yes, sir.
Did you just testify that the pools that we're talking about, the sources of supply, the Wasatch and the Uintah Butte, you consider, in your professional opinion, to be a common source of supply?
Yes, as I have testified multiple times in the past.
And the rule says that you only need to commingle if it's 2 or more sources of supply. Isn't that correct?
Yes, sir. That's correct.
All right. So why are we commingling?
We have identified these formations. We have made a distinction based on this gamma ray marker, which is used to correlate rock around the basin. And we have, and so according to that rule, it was through this transition zone. We follow the rules laid here for drilling this well, and we follow the commingling because that's what we're supposed to do based on the rule. And so I was not asked about my geologic opinion at that time, and we followed these are it's a gamma ray marker that we distinguish between these 2 formations. I mean, that's it. I've given my geologic interpretation. I think you
understand. So I understand. So what you're saying is that, in your opinion, they may be a common source of supply, but for legal or technical reasons, which you were not consulted on, they are treated legally as 2 separate sources of supply.
I apologize, but let me confer with counsel one more time.
Of course, no objection.
It's all right. I'm going to answer that question. He's asking a legal question, a legal for the put. If you want to comply with the regulatory requirements, that's what they were trying to accomplish. But the legal determination hasn't been set because there hasn't been a spacing order yet.
So I'll continue then. The next part of the rule, if you'll permit me to read that to you, and you can tell me if I've got it wrong. The application must also be accompanied by a description of the method used to account for and to allocate production from each pool so commingled. Any reason to object or dispute me on that?
No objection.
So you heard, were you present or able to hear the testimony from your colleague, Mr. Arndt?
Yes, sir.
Were you able to hear and understand when I was questioning him about the line in the sundry notice about allocations?
Yes.
All right. I asked him what the sentence that allocations, if necessary or if required, will be conducted based on the initial testing of the well. Do you recall that?
Yes, I do.
All right. Can you explain that sundry notice sentence?
You know, no, I cannot. I've testified my expert opinion that it is not reasonable to believe that we are draining anything outside of the 34-acre unit that we drilled the well on.
Just a moment ago, you testified that, and your count with assistance of counsel, in order to comply with the legal requirement, which is separate and independent, and in fact, in this case, different from your geological opinion, that you had to distinguish between the Uteland Butte and the Wasatch. Isn't that right?
Yes.
All right. And in this case, the legal requirement is that if you commingle, you allocate, whether that's logical or necessary in your geologic opinion. Isn't that right?
I'm not going to answer that question. That's not a specific question to my geologic interpretation.
I'll be happy to rephrase. As I read the rule to you, did you hear an exception to the allocation requirement for geological opinions, expert or otherwise?
I did not hear an exception for geologic opinions.
And absent an exception, aren't you required to allocate just like you're required to treat the formation separately?
I think our legal requirement is a question for counsel.
He's right. He's not a lawyer.
No further questions.
Division, do you have any questions for this witness?
No, we do not.
Redirect.
Yes.
Thank you. Mr. Atkins, you heard if there is no distinguishing factors between the upper Green River or the lower Green River and the Wasatch that would modify drainage. And if it's your geologic opinion that neither will go beyond your leasehold. And if the leasehold is common ownership, as Mr. Arndt has testified, then where is the issue here, in your opinion?
There is no issue, in my opinion.
In other words, there wouldn't be any material effect on the commingling application here.
That's correct.
And also, I would point out to the board that Mr. Hunter's commingling application that he showed on the screen is not the complete version of Exhibit F. That concludes my redirect.
Board, do we have any questions for this witness?
Yes, I have some questions for Mr. Atkins. Mr. Atkins, on the cross-section, Exhibit H, we're talking about a transition zone between two formations. and it's commonly found at the base of the Uintah Butte Formation. Is that a readily identifiable marker across the basin on a regional basis?
Yes, sir. That's the reason for the location that I picked that spot is something that's regionally correlatable.
So that for communication purposes throughout the basin geologically, that's a marker that industry generally agrees on as separating two formations. Let me ask you, on this cross section, these wells are drilled diagonally. They're not vertically. Is this cross section true vertical depth, or is it actually log depth?
Well, yes, sir. This is vertical depth. These are actually directionally drilled wells, and so you're right. It's a slight correction that through the productive interval that was completed, the well is actually vertical, and so but yes, this is in vertical depth.
Okay, and so the new tech representation you have there, that's corrected back to true vertical depths.
That's correct.
And so that takes into account of your calculations where you're coming up with oil in place has been corrected from the slant hole.
Yes, sir. But I'd like to reiterate too that through the productive interval, it is vertical, and so but yes, it is. That's correct. That correction was made by New Tech.
Okay, and then back on Exhibit H, as we're looking down on your perforations in the Wasatch Formation, we see different colors between the different logs. Could you describe what the yellow represents versus the black and the gray?
Sure.
I assume that's a gamma ray log you're showing there.
Yes, sir. That's a gamma ray log, and so this is really an interpretive way for us to highlight different zones throughout the section to make to help these markers stand out. It really has no bearing on rock type. The colors don't, but they also correspond to the gamma ray counts of that log. So typically cleaner being certain rock types, and hotter or higher gamma ray counts being other rock types such as shales, or there's a lot of variables that go into what makes those high or low. It's not just rock type, but it's also the mineralogy of that rock type. For instance, you could have a sandstone that has a high iron content or a high uranium content that gives off a different gamma ray signature compared to a sandstone that is only pure silica. So the gamma ray it's a lithology log, so to speak, but it's also a way to correlate different zones. There's a lot more that goes into the geologic interpretation than just this one curve.
Okay, taking that into account, you wouldn't necessarily say then that the log through the well in 15 versus the well in 14 is a cleaner reservoir, or perhaps that the reservoir perhaps deteriorates moving towards the well that's closer to the lease boundary?
That's actually a very good view. You could make that interpretation.
Okay, so that's all the questions.
Go ahead.
That's all the questions I have. Thank
you. Okay, yeah,
Yes, go ahead.
I'd like to ask just a question or two about exhibit, H and K actually. On K, you've got the yellow and black. Does that indicate the number of open perforated feet there? So on the left-hand side.
No, sir. There are no perforations included on that log. That information was not given to New Tech. I like to keep I want them to have an unbiased opinion of what they think the volume in the reservoir is.
Okay, so then back on Exhibit H, did that show the completed perforations there?
Yes, sir.
Okay, so you have, and are those typically 8, 10, 12-foot clusters that you have there?
Those are 1 foot clusters with 2 shots per foot in this case. The number of shots per foot varies, but we're talking about 1 foot of perforations with 2 shots per foot. So 2 holes per well.
So you've got 2 holes in the Wasatch on 12-14-9, and then
yes,
something like 50 to 100 or so up hole.
Yeah, so like I said, this is a zoom in of the bottom part of the well, just focused on the boundary between the Wasatch and the Lower Green River Formation. There are more perforations up the hole that aren't shown on this exhibit. But each one of those tick marks represents 1 foot of perforations, with typically either 2 shots or 3 shots per foot. So in this case, it was 2. So.
Okay. Were there any spinner surveys or production surveys completed?
No, sir.
Okay, thank you.
Yes. Go ahead, Ms. Garrison.
Without going back to the application and looking for, was it your intent to drill into this top part of the Wasatch, or was that a decision made at drilling? Was this your original TD?
Yes, ma'am. This was the planned TD of the well, and as you can see, right across that transitional boundary, we attempted to capture a small amount of hydrocarbons that, along with the primary target being the Lower Green River section of the hole.
Thank you.
Mr. Moon.
So just following up on that question, is this quite common then? In other words, are many of your wells commingled in this area?
Yes, sir, they are. This is a common practice.
And then just looking at the state oil and gas map, there's a lot of wells to the east. In general, are these 20-acre wells, 40-acre wells? It looks like around 16 per section, but
System check, system check.
Yes, sir. I'm here.
Thank you, sir. Please stand by. We're switching to alternate connections and restoring elements. We need a few more minutes here.
Got you. Thank you, sir.
Chairman, I believe we're able to go back on the record. We do have some minimal services as we've integrated an alternate network to try and make it through a future interruption. Core technology issue is still in play. But if court reporter is ready, I'm ready to reactivate the recording.
Okay, we're back on the record. Thank you for all your efforts for keeping us moving forward here. Any more questions or comments from any board members?
So I'll just finish my question did relate to spacing, and this is not a spacing hearing, so I'll withdraw that question. And just a comment, there's concerns here about, are we stranding some oil into the river, et cetera, but that's really a spacing question, and it would be appropriate in a spacing hearing. And here we're talking about commingling, and so I don't have any further questions.
Thank you. Yes, division.
I'd just like to ask a couple of follow-up questions, and these are pretty in line with what you've already spoken to, Mr. Atkins. You stated that it's your geologic opinion that this is one common source and supply. Is that correct?
Yes, sir.
Between the Lower Green and the Wasatch? Yes. So just to make sure I'm understanding, is it because it's your understanding that it's a decision for the board to separate those two, that you, or FINLEY rather, has gone through the process of doing a commingling? Because although your geologic opinion is that it's one common source, that determination has yet to be made by the board, and therefore you wanted to make sure everything was properly done?
That's correct.
Perfect. And then one last question on that Exhibit H. You can see that there are a lot of perforations with just a few in the lower formation, the Wasatch Formation. Would it be your expectation that the drainage from those lower perforations would be small as compared to the volume extracted from the higher perforations, given the differences in the amount of perforations?
Yes, sir. That is my opinion. That is the point of it's 1.6% of the perfs, and even if you did an allocation based on that percentage, that means that 98.4% of the production would be from above the Wasatch.
Okay. Perfect. Thank you. That helps solidify my understanding for things. So thank you, Mr. Atkins.
I have one comment too. I'd just like to thank the board and thank everyone for allowing me to testify virtually. And I apologize for the technical issues on my behalf for being virtual.
I believe we may have one more question from the board.
So for FINLEY, do you have other wells that have the state participating in, whether it be with international or other lessors along the Green River, or is this something you haven't got into a lot?
I'd have to talk to our land department about that to be specific.
Yes, sir. Not that I'm aware of.
Okay.
All right. Any more questions for this witness? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. That concludes my examination of Mr. Atkins. I'd like to reserve the opportunity to call him back as a rebuttal witness as necessary. That also concludes our presentation in chief. At this time, I would move for admission of exhibits A through H and Z, and rebuttal exhibit K at this point.
So admitted.
Any objections, Tony?
No, no objections.
And no objections from the division.
Thank you, Mr. Chairman. Then that would turn over to Mr. Hunter for his presentation.
All right, over to you, Mr. Hunter.
Thank you, Mr. Chairman. I'll dispense mostly with the opening statement. I think everyone sees where I'm coming from, but there's two problems with the commingling application. One, the location of the river. That's going to be a problem, and I understand that we've had several rulings that have attempted to steer me away from that, and I anticipate that I'm going to draw those same objections here closely. You've seen my exhibits, and you know where I'm intending to go. In anticipation of those objections, I'm going to reiterate that I do need to be able to make proffers of what my witnesses would testify in the event that the board sustains those objections. And so they might be a little lengthy, and I might be going on a little bit, but I need to preserve the record for appeal in case perhaps the Supreme Court doesn't agree with the board and Mr. McDonald's analysis of what is relevant to this commingling application and what is more relevant to a spacing. And I want to just run that by everybody here and to achieve an understanding that I see that that's kind of how we're probably going to do this.
All right, please proceed.
Thank you. First off, before I call my witnesses, I'd like to take the opportunity to talk to Mr. Dane Doucette at the division about the permitting process.
Yeah, the division has Mr. Doucette here ready to speak specifically to the APD process of the permitting.
All
right. Point of order, should he be sworn in as a witness then?
Yes. Thank you.
Could you steal one from them?
Could you raise your right hand? You do solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. All right, Mr. Doucette, can you please tell the board and Finley what you do at the division?
Yeah, I'm the oil and gas permitting manager for the division.
All right, so you see and review all of the sundry notices and APDs and APD changes that come through?
I do not review all sundry notices. I review all APDs and sundries that are tied to APD changes, which we call an amend APD sundry.
Okay, and both commingling applications and bottom hole changes would fall under that category?
Commingling would if they apply for it at the time of the APD. If it's after completion, then I would not see it. Those, and even the ones that come through the APD are all approved by Dustin Doucette.
All right. And is Dustin available today?
He is not.
All right. But you're familiar enough with the process and with the contents of a commingling application that you can testify competently to what goes into making that decision at the division?
Well, like I said, it's not my decision. I was not told that I was to be prepared to answer questions on commingling until I got here today. So, I mean, I would probably refer back to the rule. That's our requirement is what the rule says.
All right. And if I asked you a question you didn't feel comfortable answering, you just say, I really don't know, and then we can move on from there.
Sure.
Okay, great. Thanks. Let's start off with if you've seen the defense exhibits or the respondents exhibits today that filed for this.
Yes.
In this cause. I want to draw your attention to Exhibit 4, which is the permit to drill. Now I'll get that up on the screen. Paul, I think I'm transmitting. We're able to switch. There we go. Excellent. Thank you. This is the permit to drill for the Lazy River 12-914, which is one of the wells at issue in this cause. You see it at the top there?
Yes.
All right, great. I want to scroll down a little to the conditions of approval on the bottom of the first page.
If you can see that, it looks like there are 1, 2, 3, 4, 5, 6 requirements there. Does that seem right to you?
Correct.
All right. I want to kind of take them one at a time. Actually, we'll start at the bottom because that one is the most pertinent to this hearing. Downhole commingling between two formations cannot occur until the provisions of Rule 649-322, completion of 2 or more pools, have been met. That's a requirement. That's a condition of approval. Is that correct?
That is correct because they did not apply for commingling with the APD.
Exactly, as you talked about it a little earlier. Do you know if FINLEY has complied with that rule to this point?
Is my understanding that yes, they have.
It's your understanding that they have, and
But I don't. I like I said, I would not approve that. That's Dustin Doucette.
You are telling me that you don't know. That's fine. We talked about that. Thank you. The next one is conductor casing may require deepening to help protect water wells. Are you aware if they've complied with that requirement?
That was an engineering stipulation, condition of approval. That is reviewed by the engineering department when the well completion report is submitted. I do not have any personal knowledge on that review.
Okay. Surface casing shall be cemented to the surface.
Same thing.
Engineering question.
Yep.
Okay, thanks. Compliance with the conditions of approval, application for permit to drill outlined in the statement of basis, copy attached. What's that?
Correct. That's the geological statement of basis and the surface statement of basis. If there's any requirements in there, it's just saying that they have to comply with those conditions.
Do you have any personal knowledge if those have been complied with?
No.
Okay. All right. I'm going to skip the big one here for a second. We'll come back to that. In accordance with Utah Admin Rule 649-311, directional drilling, they'll submit an angular deviation survey. And I believe you might have heard testimony earlier that did happen. Do you have personal knowledge of yourself if that happened?
Without looking in the well file, I could not answer that one way or the other.
That's fine. Thank you. I'm going to come back around to the big paragraph in a minute, but first I want to ask you, on all those requirements as conditions of approval, what happens if they don't do those things?
Then they would be issued a notice of violation.
All right. And what's the consequence of being issued a notice of violation? Potential consequences. There's a range, right?
There's fines based on our penalty rulemaking that was passed recently.
Right.
Correct.
And just for argument's sake or potential applications, what's the worst thing that could happen for violating one of these conditions of approval?
Without having the rule in front of me, I'm not sure I'm comfortable answering that question. I'm not the compliance specialist for the division. He handles compliance and fining and those type things. So somebody could look in the rule. I don't know it off the top of my head. I mean, I know the maximum fine per violation is $200,000, but other than that,
I mean, theoretically, maybe not for these particular violations, but theoretically, the well could be shut in, I suppose. You could order, if you issued an order to show cause and they didn't meet standard, you could shut in a well, theoretically.
I would say that's a legal question.
All right. That's fine. I'll accept that answer. Thank you, Mr. Doucette. I am going to go back to the final requirement here. This proposed well is located in an area for which drilling units, well spacing patterns have not been established in order through the order of the Board of Oil, Gas, and Mining, the board. In order to avoid the possibility of waste or injury to correlative rights, the operator is requested, once the well has been drilled, completed, and has produced, to analyze geological engineering data generated therefrom, as well as any similar data from surrounding areas if available. As soon as is practicable, after completion of its analysis, the operator is requested to seek an appropriate order from the board establishing drilling and spacing units in conformance with such analysis by filing a request for agency action with the board. I get that right?
You read it correctly, yes.
Thank you. All right. So there's a couple, I hit these words a couple of times in there, and that's requested. That's different from the other 5 requirements in there. I don't see requested in the other ones. Why is that in there?
One, that condition had been added well before I took this position. When I took this position, I asked about that. I can't remember the exact meeting, don't have notes, but it was with the board and with division management. And it was just, the reason it says is requested because there's nothing in the rules that say they have to come before the board in space. So it was decided to leave that in there because we would like operators to come in space. That was the guidelines I was given that we would like them to, but there's nothing in the rule that requires them to. So it was left in there because, like it says, we would request they do it, but we had no basis to require them to do so.
But it's stuck there in the middle of 5 other requirements that, as you testified, you could be issued notices of violation for, right?
Correct.
So why is it in there?
Well, like I said, I don't have notes, but I explained why, and it's where it shows up in there as a matter of our electronic permit programming. It just sticks it in that place. I mean, we could have the IT department reprogram it where it shows up somewhere else. But like I said, upper management said they wanted to keep it in as a request, but so we didn't take it out. But anyway.
Yeah. Are you aware that you're probably aware through the course of your everyday job that it's the policy of the state of Utah, it's in the general interest to preserve correlative rights, protect against waste, and to maximize recovery of the resource? Are you aware of that?
Yes.
Yeah. In your experience doing the APDs and the petroleum or the well permits, does spacing tend to accomplish that goal?
I believe that's a requirement for all spacing orders that is shown before they're approved. But I mean, that's a board decision.
But it's almost, to use a mathematical term, an identity, or the philosophical, a tautology. If you are spacing, you are preserving correlative rights, maximizing recovery, minimizing waste. Think that's right?
I mean, like I said, it's a board decision, and I think those are requirements for the board to buy off on before they approve a spacing order. My thing is just to enforce the rules and the orders. So,
and there are rules about the other 5 items in that conditions of approval.
Correct.
But the basis of this request is the policy of the state of Utah. Is that a fair statement?
I don't know if it's a written policy or a practice, but I would say it's at least been a practice. And
would you have any basis to disagree with me if I said it's the first section of the Conservation Act under 40-6-1?
Would not be able to answer that without having it in front of me.
Okay. But you wouldn't have any reason to disagree with me?
I wouldn't have any reason to agree with either.
That's fine. All right. That's mostly for the benefit of the audience. All right. So let's move on from the APD itself to the from the application for the permit to drill, to the application for permit to drill for the -14. You heard testimony, I'm sure, earlier from Mr. Arndt that the well location had moved to a new bottom hole. Is that right?
Correct.
All right. And what I've got here under Defense Exhibit 2.2 and 2.1, I'll go back to 2.1 first, is the sundry notice for the revised well. And the received date for the division under that is August 31st, 2021.
Correct.
All right. And this sundry notice was submitted after August 26th, 2021. Is that right?
I believe August 31st is after August 26th, correct.
Right. Is there significance to the August 26th, 2021 date with relationship to the well, the 14 well?
Not off the top of my head.
Do you recall when the application, off the top of your head, for the 14 well was approved by the division? The effective date?
I do not.
All right. Let's go down to... Actually, I'll withdraw that question. On the map, let's go to 2.2 now. On the map, you see that the blue line, the blue zone is off the side of a river, or off the side of a line reported to be the river. Is that your understanding of this exhibit?
That is my understanding.
Do you recall from earlier testimony if that river, that line that purports to be the river, was on the earlier exhibit, on the earlier application?
The original APD application?
Correct.
I don't believe it was.
All right. And does the division check the surveys? If a new survey comes in and changes the bottom hole location, does the division check on those?
Yes.
How do they do that?
We'll look to make sure it's meeting either siding requirements or the applicable spacing order.
Right. Do you check the underlying lines on the paper, let's say? If a survey comes in, do you question or investigate the position of the new lines on the paper?
I do not. I know the engineering department does they have some kind of check. I do not.
Right. So someone in your department, to the best of your knowledge, looked at that new line and said, yeah, this works.
Correct.
Do you know if they did any checking underneath what the line consisted of?
I do not know.
Does the division have a title department?
No.
Is anybody there giving opinions or trying to find out whether or not someone owns a piece of property or not?
No.
You just take the word for the person submitting because they certify that what they're giving you is the truth, right?
Correct.
All right. Do you ever, as outside of an opposed sundry notice request, any sort of submission, is there ever an adversarial process to double check sundry notices or APD changes?
I'm not sure what you understand. I'm not sure I understand what you mean by adversarial process.
Absent an objection, absent someone saying, I don't want the division to approve this, let's hold this up. Is there anything internally that you do that could say, hang on a second, let's hold this up?
Sure.
Yeah. Like what, for example, what would it be?
Well, let's say you're looking at this one and the bottom hole's 100 feet to the east. It's outside of that drilling window box. And they didn't request an exception location, I wouldn't approve it. We would send it back and say you need an exception location.
Right. So if there's something that's just clearly on the map, that you can't do that. You're not going to look underneath it, but if there's a line on the map that doesn't seem to work, someone inside the division should be saying, hey, we should stop that.
Correct.
For a second. Okay. So can you think of any examples in the recent past where you've seen that maybe?
I probably couldn't come up with one example in particular, recall the well, but yeah.
Right. If I showed you such a thing, could you tell me if that might have tripped a wire? If I showed you an example of that?
Sure.
Okay. I previously provided Mr. McDonald a stack of what I'm calling memory refreshers, but I'd like to offer this as a demonstrative to show Mr. Doucette so that he can illustrate for the board how his internal processes might catch something. I'm just wondering if Mr. McDonald has an objection to that. Absolutely. I'm handing Mr. McDonald 3 examples, and let's give him a moment to look at those.
I would object to the relevance to this hearing since we're dealing with these 3 wells, but none of these exhibits pertain to the 3 wells.
What are these exhibit numbers, or is this something that we have had submitted?
No, I intend to use these as demonstrative only to illustrate for the board that there is or should be a process within the division, even though they don't worry about title, and they're not going to. They are under no obligation to investigate a new line.
All right, please proceed.
Thank you, Mr. Chairman. All right, so I'm going to just to make sure that we're not accidentally revealing things we shouldn't or things that haven't been vetted yet. I'm going to turn my display off for a second while I locate and maximize the screen for those. One moment, please. I think I've got that up. Put that back on the big screen so everyone can see. All right. All right, Mr. Doucette, I would like to direct your attention to the screen here. Can you tell the board what this appears to be to you? And I can move stuff around or make it bigger or smaller, whatever you'd like. So just ask me what you'd like to do.
It's a well plat that's typically required with any APD submittal.
All right. And I'm going to zoom it out just a bit so we can get a bigger picture of it. Can you read the received date there at the bottom?
October 28th, 2020.
All right. And so this was a couple years ago. And let's try to locate ourselves here. This legal description here, Township 5, Range 3 East, Uintah Basin Meridian. Can you see that?
Yes.
All right. And would you have any reason to disagree with me to note that the Green River is down here at the bottom?
That's what it looks like, yes.
All right. And it appears to me, and you tell me if you disagree, that the blue line looks like the edge of the Green River.
I think it's been pointed out abundantly today. We don't know what that means.
And you're not going to question, are you, at the division, right?
What's that?
That's not your role to question.
No.
No. But at first glance, looks like where the river is, right?
That's what it looks like on the plat, correct?
All right. And as you've heard many times today, the boundary line between the river and the land is the boundary line between what the state owns and what maybe it's feds or the Indians or fee, what a landowner owns, right? The ownership of the Green River by the state of Utah FFSL is what's at issue here today.
Correct. I mean,
yeah,
they say they own those rights.
Okay.
I know the Ute tribe owns some of them.
So at first glance, even just not knowing any of that, do you think that river line looks like a property line? Would that ring a bell or raise a flag with somebody just looking at this?
Not necessarily. If they're drilling in the center of a equivalent quarter section according to state siting rules, it may not.
So the fact of the matter is that a line through a drilling window might mean nothing and might raise no flag at the division for the purposes of deciding whether or not an exception location is required for a well under the siting rule. I don't want to misunderstand what you're saying, but I want to make sure that we get that right.
I would say that it's correct.
I'd just like to object. We're kind of straying off something that's completely irrelevant to the current discussion. This is a hypothetical situation. The division would like to get back on track to the commingling at hand.
Sustained.
Want to turn your attention then to the APD. Oops, I'm sorry. Actually, I'll close my screen off again. And before I continue on, may I proffer? Thank you, Mr. Chairman. The other two exhibits will be similar. The exhibit that we have here depicts the river going through the drilling window. The siting rule says you need to be the drilling window itself needs to be 460 feet away from a property line. And even though the division's internal processes might not have a mechanism to catch that, to channel it into, well, you're going to need an exception location, which requires notice. The fact of the matter is that should have been a situation where notice was triggered and required. The next exhibit is going to show a plat map from an APD on the river where the well itself, the well window itself has been moved from the substantial center of the substantial quarter section south by about 160 feet. so that rather than the window starting at 460 feet from the south part, starts at 322, I think.
Mr. Chairman, I'm going to object to that. Mr. Hunter's
in the middle of a
testifying here. He's testifying. Okay. And if he's got witnesses that want to talk about that, that's fine. Or if he wants to reserve this for legal argument at the end of the hearing, that's fine.
I'll stipulate that if I can have a witness, one of my witnesses talk about this, and he lets me complete that examination for one of my witnesses, I'll be happy to do that.
So stipulated. Huh?
All right. Well, I'll bring this up on direct examination with Mr. Nathan Wixom then. That understood? Is that okay, Fred? Okay. Then I'll move on. Mr. Doucette, I would like to direct your attention to defense exhibit or respondent's exhibit number 3.1. And the first bed, 3.1, is the application for permit to drill for the 12/11/9/19.
Objection, relevance.
Please proceed.
And Mr. Doucette, if you look at the bottom of that, that was approved on August 26, 2019.
Correct.
About the same time as about a year earlier, I guess, from the 12/14 change. Is that about right?
I don't remember the exact day, but
Yeah,
sure.
Okay. So this has been going, these wells are from the same surface location, and I can look at that. Location of surface 182 from the south line, 2875 from the east line, or the 11 as compared to sorry, I'm scrolling a lot here. 1,043, 2884. Surface locations are similar. Probably from the same pad, maybe?
Probably so.
All right. Direct your attention to the plat map that immediately follows that for the Lazy River 12/11/9/19. Bottom hole location, the surface location where we discussed, and the bottom hole location off to the northwest. Do you see where that's depicted there?
Yes.
Is that inside or outside of lot 7?
Can you scroll up a little bit?
Absolutely.
No,
the other way.
The other up.
My fingers move up on the pad. All right. Does that help or does that make it worse?
No, that's fine. Well, it's whatever.
Looks like it's in lot 5 to me. That seem about right?
No.
No?
To me, that looks like it's 5 feet north of the lot 5 line and 5 feet east of the whatever that borderline is to the west there.
Whatever the borderline is to the west, it's not marked. I agree with you.
I can't. You'd have to scroll.
Sure. Let's go down to see if the legend has anything to help us out.
Yeah, I don't see where it says.
You see there at the bottom, I think we might be looking at a 16th section line or a quarter maybe.
Yeah, it's not marked.
It's not. Well, I just want to make sure that we're looking at the same thing. The very bottom line of the legend, 16th section line, long dashes, no dots. And if we look over here, just west of lot 7, long dashes, no dots. Looks like maybe a quarter section, same long dashes, no dots on the demarcation between lot 7 and lot 5.
Correct.
I mean, I understand your hesitation because it doesn't look like a quarter section line, does it?
No.
Maybe something's missing on this plat. Do you think there might be something missing from this plat?
I mean, it would definitely be better if they showed other.
If I scroll up to the amended 14 plot and showed you that, you think you could identify what might be missing?
Well, I mean, that one has the river buffer on it, but.
And it kind of tracks, doesn't it?
With what you're saying, the 16th section line? Yeah, it's similar.
Similar. It curves and goes back and forth over the section line, but it kind of tracks. So is it fair to say that on the section 11 is the line between lot 7, lot 5, the regular terrestrial aliquot parts and lots, and the Green River?
Yeah, very well could be.
All right. And I know it's not your job to check title, and I know that's not the division's role, but that is a property line of some kind, right? I mean, there's a quarter section line, and we're having a tough time just sitting here talking, knowing what that is. Is that right? Knowing what's on the other side of that 16th section line?
Correct.
Yeah. So I'm going to scroll back up again to 14. Look at that. I'm going to put my cursor over and sort of circle around lot 5 there. If we thought about it and kind of projected, that drilling window is over here to the east of this line purportedly surveyed by a surveyor on behalf of FINLEY. Is that a fair statement, you think?
That the drilling window from the other plat is approximately there? Is that what you're getting at?
That's correct.
Yeah, appears so.
And that will appear to be a drilling window inside the river, the course of the river, wouldn't it?
It looks like it might touch it.
At least touch it. Maybe in it, but at least touching.
I'm going to go ahead and object. So, Mr. Hunter, you've established and acknowledged that the division doesn't need to do title work and is not in a position to speak to where the river is located and where these plats might be located. Is that true?
That is absolutely correct.
Then can I ask why we're being asked about this?
Absolutely. I'd be happy to explain if the board has no objection to explain the relevance. I hear kind of a relevance objection, so I want to.
Yeah, that's essentially what it is.
Okay.
Yes, so no objection, but I do, and I don't want to unduly constrain you, Mr. Hunter, but we do have a hard stop at 6. I think we lose this real estate at 6. We need an hour of deliberation, and to be honest, you were not moving like an arrow towards what I can see. Well, I don't know where we're going.
I understand.
So if we could move forward vigorously.
Happy to explain.
Without constraining yourself, but we do have some time constraints beyond our control.
Understand, Mr. Chairman. Thank you.
Thank you.
No, I'll be happy to explain the relevance of this. The division's internal processes don't have a title check, and the only way that any member of the public who has correlative rights in nearby parcels can rely on the protection of the board and the division is if there is a check internally somehow that says we need to investigate a little further. It's not really our job to investigate fully on this, but there's enough irregularities here that we need to make some further inquiry as to what is actually happening. And if the section line, the 16th section line, isn't with no label or anything on the other side, isn't enough to trigger a red flag for an APD that was approved from the same well pad as the other 3 wells at the subject of this commingling request. I have some questions about whether or not those checks are active enough to protect the correlative rights of people next door.
Mr. Chairman, I'm going to renew my objection that if there's irregularities, they should pertain to the 3 wells we're talking about and not another well that's not part of this hearing.
The division joins that objection and would also point Mr. Hunter to further down in the rules on point for an APD where they have the opportunity to protest APDs should they want to.
Sustained. I would ask that if you have something that's pertinent to these 3 wells as far as the inadequacy or adequacy of their step back from the property boundary, that would be most useful to know about. Has someone been out to look at the site and see it, or used an aerial photograph, or done any number of things a geologist working for a couple hours could figure out? Hey, maybe it's not the 460 from the river boundary. That would be most helpful. Huh?
All right. Then I have no further questions for Mr. Doucette. I'd like to call Mr. Nathan Wixom and Mr. Brian Wixom to the stand, please, to be sworn in.
Do I have an opportunity to
Yes,
cross-examine?
I apologize.
Yes, Mr. McDonald, do you have any questions for this
I do,
witness?
very quickly. Mr. Doucette, as far as you know, were the APDs for the 3 wells at issue approved by the division at the location submitted?
Yes.
And if you can answer, I know you've testified, but for the protest of International Petroleum, would the commingling applications that were filed be approved by the division?
That is my understanding.
Yes, thank you. That's it.
Does the division have any questions for the division?
Yes, just a short redirect. Mr. Doucette, is it your understanding that the division is supposed to rely on licensed surveyors used by operators when they submit their APDs?
Yes, that is correct. That is one of our requirements for an APD.
So it's not the division's role to go back through and confirm everything in a licensed surveyor. It's the division's role to just make sure that these operators are using a licensed surveyor.
Correct.
Perfect. Thank you, Mr. Doucette.
Any questions from the board for Mr. Doucette? Mr. Moon.
So at what point is a application made public? Is it when it's filed for or just when it's approved? When does it go on the website?
I'm not entirely, the old system, it was only when it was approved. I believe, and the reason for that was we'd start getting a bunch of complaints about something that we might send back anyway and have it changed. But if I'm not mistaken, I believe you can actually see them when they're submitted now, but I'm not 100% positive.
But you're certain they're public once they're approved?
Yes.
Okay, and so if someone sees an approved permit that you're encroaching on me, what's the process? How quickly do they just contact you directly, or do they have to come before the board, or what happens?
I'd have to look at the rule game, but I believe the requirement is they have to petition the board, is the way the new, when the changes were made to the operatorship rule, 2 years ago or whatever, I think the requirement is they have to come before the board. I mean, they can protest to me and I can do some initial checks or whatever, but I think to preserve their rights, I think they actually have to file something with the board. But that's just my recollection and understanding.
Yeah, and I can confirm that the regulations, the rules we have in place require them to file a request of agency action. They have 10 calendar days from the time that it's posted online to file that request.
Ms. Garrison.
Are confidential APDs, once they're approved, show up on the public website?
Yes, because the APDs are never confidential. It's only the information that follows. An APD is never considered confidential.
Thank you.
Any other questions from the board? Seeing none, I guess it's back to you, Mr. Hunter.
All right, thank you. Actually, I would request a 10-minute recess to confirm with my clients, just for real briefly. I understand we have a hard clock, and with the fact that I wasn't considering you guys need an hour for deliberation, you might lose that. That sets my clock back. I'm going to confer with my client to see if there isn't a streamline that we can do.
Please do.
Okay, thank you. It should only be 5 or 10 minutes. Thank you.
We are off the record.
tedious. The only time we ever had anything similar to this is when Tony Hunter was objecting to the rulemaking that was going on about 3 years since I've been.
Okay, who's Tony?
That guy.
Oh, okay.
So, doesn't usually happen.
Is he doing it to justify his salary?
I don't know. I think it's just his personality.
Yeah.
It's the only mode I've ever seen him in.
That's what happens. That's why judges
He loves to intimidate his witnesses.
Chairman, the recorders are running, ready to resume it when you're ready.
Thank you. We are back on the record. Mr. Hunter, back to you.
Thank you for the break, Mr. Chairman. That it was a productive break. I understand that we also have additional constraints that our court reporter will be leaving us in about 50 minutes. Is that correct? Does I understand that correctly?
At 5 o'clock.
At 5 o'clock. Oh, I'm sorry. My clock is on Central Time. So an hour and 15 minutes. Thank God. I thought this would just got a lot worse. Okay. Whew. Okay. So that would have ruined the plan we just made. All right. So we have a somewhat of an itinerary to conform to not only the problems we've had technically, but the constraints of the court reporter. So what I am going to do at this time is proffer the testimony of Brian Wixom, managing member of International Petroleum LLC. Based on the previous course of decisions and how the board's going, I anticipate it will withdraw an objection for Mr. McDonald. So the proffer will serve as a way for Mr. McDonald, if he deems it necessary, to object to that. My proffer will be on the record of what I anticipate that I would elicit from Mr. Wixom if the objection was overruled. If the objection was sustained, then it's there and it's preserved for appeal. Once that is cleared up, I'll either examine Mr. Brian Wixom, which will take some time, but I will shorten it because I anticipate that I'll know. I have a very clear idea of what is going to draw that objection. If it's sustained, then I'll call Mr. Nathan Wixom, who is going to have his own testimony, including a stipulated piece that Mr. McDonald has already said I can examine a witness regarding. Then Mr. McDonald will cross the division. It will have its opportunity as well, and then we'll move to closing. Hopefully, I think that should get us in under the wire and get that resolved in a timely fashion.
Thank you for working under these time constraints, and please proceed.
Thank you, Mr. Chairman. All right, so I will proffer Mr. Brian Wixom's testimony that if he was allowed, well, not yet. You're not swearing yet. Okay, but thanks for your enthusiasm. Just a second, I'll pull up my outline here. All right. I would proffer the witness testimony of Mr. Brian Wixom. If called to testify, I would expect to elicit the following points: that he is an experienced oil and gas landman running his own company for 30 years, operating, leasing, all facets of oil and gas operations, both as an operator, non-operator, landman, lease hound. He understands that the Division Forestry, Fire, and State Lands leases are kind of unique in the field. They have interesting title problems to them, interesting title considerations, including vague descriptions on leases that have to be determined after you purchase them, because the owner doesn't know exactly where their interest is located. He's aware of that when he makes that purchase or that sale. DFFSL also has road leases. Those have the same legal restraints, including a protection from drainage requirement. He is obligated to protect those wells from drainage actively. And those have different title problems, being that they're not nice, neat squares. They're not aliquot parts. They're a line marked off by meets and bounds, and then a center line, and then a width extending from the center lines. He has had to defend his title against challenges and defend the state's title against challenges in the recent past. So he is no stranger to these things and accepts those obligations and discharges them willingly. He would further testify, I would elicit the testimony that there's been a long line of negotiations starting in 2018 or 2019 with FINLEY to attempt to develop the entire river acreage cooperatively to avoid the concept or the necessity of defining the river boundary. Mr. Wixom was aware of this as an issue at Lease purchase in 2015, and he worked diligently to try to work around it, to try to make it so it wasn't an issue. Those attempts were not successful. FINLEY was not interested in doing a long river deal to ensure that the state wouldn't have to demarcate every single foot of the river. Those deals or attempts of negotiation eventually culminated in an offer. Wasn't acceptable to Mr. Wixom, some additional back and forth. But it finally culminated in a small deal wherein FINLEY acknowledged that there were 6 wells in the area we're talking about, Section 12, and just to the south in Section 13, the part relevant to this commingling application, that they'd be interested in doing a cooperative deal on this portion of the river. But again, the terms were not favorable, and Mr. Wixom decided that that wasn't the best idea, but counter-offered, again, with another wide river deal. That also was rejected. This time, FINLEY came back with an ultimatum. You do our deal or we move the wells. Mr. Wixom called their bluff. It wasn't a bluff. Further, Mr. Wixom would testify that his objectives here are to get a fair deal for his lessor. He's obligated under the contract, but it's his business practice anyway. He will tell you that he's been paying attention to other wells in the area that FINLEY operates and he participates in, or wells that he has interest in nearby, including one about 8 miles to the north of the relevant acreage here that is spaced on 20 acres. It actually, let me rephrase that. It's spaced 2 wells per 40 acres, 20 acre equivalent, and that those 2 wells have drained the surrounding spacing units such that it's no longer economical to drill additional wells in that zone, which in his mind means that that spacing might be too small. That might be too many wells drinking out of the same milkshake. His objective is to develop as much of the state's acres as possible. He has experience in doing a well spacing, including the Moroni number 1 well before this board in 2015. And his concern is that by commingling, that the geological evidence of the production from the different horizons and reservoirs are going to distort the best evidence available for communication between the 3 wells at issue here. The ship has sailed in other parts of the river. It's too late, but for the purposes of the area south of the river, these 3 wells and their ability to interfere with each other, drain each other possibly, would be the best evidence of what true spacing might need to be done. And unfortunately, FINLEY has all that data. We do not. And so by delaying or denying commingling, it preserves that evidence that can be used in a upcoming spacing hearing. That would be my proffer of Mr. Wixom's evidence. Over to you, Mr. McDonald.
Yes, Mr. Chairman, I would object in several accounts. First of all, the relevance of anything about the river other than adjacent to Section 12 as relevant to this cause. I would object to any testimony Mr. Hunter gave as his opinion or towards anything that FINLEY may have intended or stated. I also am going to object to Mr. Wixom's not being a qualified geologist or a petroleum engineer to make determinations on any geologic evidence or engineering reservoir.
Yeah, the division would also like to note that in the proffered testimony, Mr. Hunter has indicated an affirmative obligation to protect its leasehold interests from drainage. That affirmative obligation should have been brought up in a protest to the APD when submitted and went public, as opposed to during this current commingling request, and would be better suited in a spacing order that should be forthcoming.
Yes, Mr.
Thank you, Mr. Chair. Just a brief response to Trevor's point. Our position has been this entire time that the notice requirement of not putting it in the center in the siting, according to the siting rule, has been a way to avoid giving us notice. Now, I understand the point has been raised by a couple of board members that, well, it's public, isn't it? The window for protest is 10 days. If you're out of town for a week, if you say went to NAPE or something like that, or went for Christmas vacation, or just were, sick with COVID, let's say, you miss your window to protest. And so the fact that, yes, it's out there, it's public knowledge, is not the same thing as, say, constructive notice of the legal description in the county records.
All right, Mr. Hunter, please proceed.
We just need a ruling on my proffer, that's all.
That's my. I've overruled the objections. Please proceed.
So we're going to get testimony from Mr. Wixom, from Brian Wixom.
I don't
know. Just want to make sure we get it right. No. Hey, hold still. It's Richard's first time. It's fine. He just meant it the other way. It's okay.
All right, I'm going to overrule those objections so you can continue to move forward, but you are aware of our time constraints, and let's move forward as rapidly as we can.
So I'll call Mr. Wixom to testify.
I'm confused here. I thought the idea was you were proffering his testimony to skip over that, and if the objections are overruled, then why isn't the proffer accepted?
Forgive me. I was momentarily insane. I will sustain the objections and then please move forward.
Thank you, Mr. Chairman. I think we're clear now. Yeah. No. Yeah, get back. All right. Thank you, Mr. Chairman. The objection was sustained. The proffer is on the record. I believe I've preserve that issue for appeal if necessary. Thank you. I'd like to call Mr. Nathan Wixom up to testify now and have him sworn.
You do solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, thank you. Mr. Wixom, please state your name and business address for the record.
Nathan Wixom, 4834 South, Highland Drive, Suite 200, Salt Lake City, Utah, 84117.
All right. And Mr. Wixom, what do you do for work?
I wear a lot of different hats.
Name a few of them relevant to this application.
Land, GIS, mapping, anything relevant or needed.
All right. So your day-to-day work is basically consisting of looking at legal records, correlating them with maps of the area, and basically aspects of oil and gas production and exploration.
Yes.
All right. In your day-to-day work with International Petroleum, are you privy to communications between your legal representative and operators with whom you deal in, say, commingling applications?
Absolutely.
Were you included in a number of emails between myself and Mr. Arndt of FINLEY Resources earlier this year?
Yes.
All right. Fred, I'm going to provide you with a copy of a printout, number of emails between myself and Mr. Arndt dated earlier this year.
Are you going to submit this as an exhibit?
Not at this time, but I may need to use this to refresh my witness's recollection of the exact words of the email chain.
Then
It's been a while.
ask him the questions and see if he needs to be refreshed memory.
Mr. Wixom, do you remember when IPLLC objected to the commingling application?
Yes.
Do you remember when that date was?
No.
If I showed you an exhibit, would that refresh your recollection? Say the protest letter? All right. I'm going to show you petitioner's exhibit.
Is it going to come up on the screen?
It should, yes. Okay. Show you petitioner's exhibit. I believe it's...
I'll stipulate it's part of Exhibit G.
Thanks, Fred.
I'll also stipulate that the date was December 22nd, 2000. 21.
Excellent. Mr. Wixom, do you recall when Finley responded to that commingling objection?
Yes.
What date was that?
It's vague.
All right. If I showed you that, would it refresh your recollection?
Yeah, I think it would.
All right. This is also part of Exhibit G. I'll direct your attention to the top of that letter from Finley Resources to myself.
I can see it. Yep.
And what's the date on the top of that?
January 31st.
All right. And do your understanding and recollection, that's slightly more than a month between the application objection and their response.
That appears to be a lingering delay. Yes.
Okay. And did you attend NAPE in early February of 2022?
Yes.
And what do you usually do for NAPE?
Interact with other oil and gas companies and generate prospects or sell prospects, things like that.
All right. And does that usually take a lot of preparation?
Yes.
Does it usually take a lot of time to recover afterwards, catching up from work that was neglected during your time away?
Yeah, you can count on the week before and the week after.
A lot of other oil and gas companies there?
Yeah.
Was Finley there?
Yes.
All right.
Gotcha. That sounds better.
Thank you very much. I appreciate that. All right. And so let me move forward a little farther in time. Do you recall getting an email from me responding to an email from Mr. Arnott Finley regarding the commingling?
Yes.
All right. And do you remember any particular time when that occurred?
I don't remember the exact details of the dates.
If I showed you an email, would that refresh your recollection?
Absolutely.
All right. I'm showing you an email chain that begins at the top. It begins at the end, as email chains usually do.
Does it need to show up so I can see it?
It will in a moment.
Okay.
I'm showing you an email chain that starts at the top that I've handed to Mr. McDonald with the date of May 11th, 2022, and continues on through down at the end with the date of February 25th, 2022. Does that refresh your recollection of what the dates were for this time period?
That sounds correct.
All right. Now, February 25th, 2022, do you recall that, what, if anything, I relayed to Mr. Arndt at FINLEY?
I don't.
If I let you take a look at this and put it up on the screen so everyone can see what I'm looking at, that might help you. All right, this is the February 25th email, and take a moment to just read that real quick to yourself. And please just briefly summarize or read a highlighted sentence or two, or read a sentence or two that you believe captures it.
If it would help, I would give my hard copy over to Mr. Wixom.
Oh, we have additional hard copies if that's more convenient, Mr. Wixom. Is that easier? What do you prefer?
I'll just read what everyone else can see too.
Okay.
Everybody else shouldn't be reading it. You should be.
Oh.
I would object to it being on the PowerPoint if it's for refreshment.
I will take it down. It's at the beginning. All right, apologize for the delay. This was not as rehearsed. All right, let's flip to the very end. Go back to front. There you go.
Okay.
Yeah. Has your memory been refreshed?
Yeah.
Okay. So briefly summarize maybe the first paragraph. What did I open with?
Basically that just basically that we have concerns. We're trying to protect the correlative rights of our lessor, and that, you know, potential drainage could be occurring, and we don't. We want to include the state in this process to alleviate any concerns and get to an amicable situation.
All right. And if you would look at the second paragraph, what's the main thrust of that?
So basically, just voluntary pooling is the best solution, and in all parties involved.
Do you recall if there was an attachment to this email that I sent?
Yes, there was.
What was that?
It showed, this one I believe was 80-acre proposal where we could share on the parcels where they're irregular, smaller than 40 acres, kind of like lot 5 or lot 7. And then the river, and then the other side of the riverbank where it's also irregular, to make that one unit. And then there's no reason to play games or game the system with the rules.
So essentially, by combining both banks of the river and the river's course, if we can achieve a voluntary agreement between FINLEY, IP, and FFSL, we don't need to know where the boundary of the river is because we just agree to allocate costs and production in a certain manner.
Yeah, as long as
Objection.
the state's on board.
Mr. Hunter is leading the witness on this. Ask the question and have him answer what the question is. I would also question foundation on this from the standpoint, Mr. Wixom, did you direct Mr. Hunter to put this in this letter, or did Mr. Hunter write this?
I was privy to I was carbon copied on this email.
I know, but did you direct what was stated on there?
Maybe I can lay some additional foundation if you'd like, Fred. That might help.
I would,
understand
because
that's fine.
the way it's looking right now is it's you wrote these, and
All
he's just saying, yeah, this is what it says.
Okay, and that's fine. Mr. Wixom, is it?
Sustained.
Okay, I'll lay some additional foundation. Mr. Wixom, I'm your attorney, correct?
Correct.
For IP LLC.
Yes.
Are you involved in the day-to-day operations of this company?
Yes.
Is the decision making rather collaborative in your company?
Yes.
Does it consist of a number of brothers?
That's right.
When there is an objection or a board hearing or any kind of conflict with an operator or anyone else, is there typically a phone call where the members of the company and the workers in the company direct me more or less collectively what to do?
Yes, it's usually me. Yeah.
And do I usually obtain permission from you to send something?
Yes.
Mr. McDonald, is that a sufficient foundation for you?
Well, did he direct the specific correspondence to you on this? That's what I want to know.
Mr. Wixom, did your company direct me to make a proposal to FINLEY on 80-acre voluntary spacing?
Absolutely.
All right, that's the question I was asking.
Okay.
All right, Mr. Wixom, then if you just look at the very bottom, and actually, Mr. McDonald does raise a good point on the leading part of it. What do you understand is the value of not dealing with the river boundaries?
Well, there's a lot involved with, say, title opinions. There's a lot involved with correlative rights, and just to make sure everyone voluntarily pools and plays fair in the sandbox, then it's the best way to go about developing.
Were you here when I was talking to Mr. Arnn about Exhibit 6 that we submitted, the mineral leasing plan?
Yes.
All right. Did you get a chance to read that?
I did.
And did anything jump out at you as something that was important?
Yeah, so this was a 2020. So this happened after we acquired the lease in 2015. It was originally done in 1998, but in 2020, this plan, it said the high water mark. That was an interesting phrase that caught my eye. That's what we need to be looking for. And so I've looked at a lot of different surveys from statehood and other surveys along the line over the years, looking at different floodplains. I've talked to people that live out there. We lease people that this one family, they're about a half mile from the river, and every year it floods, and they're called the river rats. kind of teased. Anyway, that's irrelevant, but I don't know why I just brought that up. But anyway, so there's a lot involved in. Can you restate your question?
Well, no, I think you're actually answering it very well. The ordinary high water mark jumped out at you because it led to a lot of other concerns.
Yeah, like when you're on, say, a road, you have something you can walk out on. You can walk on the center of the road. Say there's a UDOT lease,
which is also owned by FFSL.
Yeah, you can, and then you have something you can actually survey, that there's something ground, there's like a stake in the ground or something like that. With a river, it's not like that.
Your understanding then is that the ownership was a little vague on the lease itself, where exactly your boundaries of your lease were.
That's right. It
And
said the bed of the Green River.
Right. And your understanding of then, after reading the mineral leasing plan, is it not correct that the state will decide on a case-by-case basis for demarcation?
Yeah, that's the last line of that exhibit.
All right. So let's continue on with our email conversation. I submitted an 80-acre voluntary pooling agreement at the direction of IPLLC.
Yeah.
And then we received a answer back from Mr. Arndt at FINLEY. You remember when that was?
It's probably, which way?
Do you remember when it was? Is that did you?
Yeah.
Okay.
Yeah, it was.
You remember when the date that we?
I don't remember the exact date, but
If I showed you the email, it'll refresh your memory.
yeah.
Okay, I'll show you that email.
Okay, so February 28th.
Mm-hmm. And just read that silently to yourself to see if your recollections are refreshed.
Okay. Yes.
Okay. Do you remember in that email if the offer was accepted or rejected?
It's kind of like he's going to run it up the flagpole, basically.
Okay. And do you recall if they mentioned involving the FFSL in these discussions at all?
No, I don't.
Okay. And did he give a timeline or an idea of when we might hear back from him?
The next few days, yeah.
Okay. And do you remember if he followed up on that?
Oh no, no.
You remember if he followed up on that, Mr. Nookson?
Yeah, he did follow up.
You remember when that was?
March 2nd.
March 2nd. Okay. And do you remember what the gist of that email was?
I don't recall.
If I showed it to you, I showed you an email printout, it would refresh your recollection? All right.
Okay.
Okay. Oh, yeah.
Wait, that was.
Yeah, you're right. You're right. That's it.
Okay, March 2nd. Yeah.
Does that refresh your recollection a little bit after you read it?
Basically rejection to pull voluntarily.
All right. Did he mention FFL in the email?
No.
Did he give a reason for the rejection?
They're compliant. They're checking all the boxes, so there's no need to do a deal.
All the boxes. What boxes are they checking?
I mean, like compliance with they're getting the approvals for APDs.
Right.
Let me just.
They asserted that their wells maybe were.
I don't want to misspeak. Let me.
Okay.
Let Mr. Wixom testify.
FINLEY believes it is in full compliance with the rules and regulations regarding the location of the 3 subject wells. So they did not want to do a deal.
Okay. And did we respond to that?
Yes.
All right. When was that? Do you recall?
I don't remember.
If you looked at an email, would it refresh your recollection?
I think it would. I think
Okay.
it's right here.
It's right here.
2 days later, March 4th.
Yeah.
I mean, just briefly.
And tell me if that refreshes your recollection.
I think this is when we strongly advise them to let's still try to work this out. We know that we want to avoid litigation and let your legal counsel know that.
So if I'm understanding you correctly, at this stage of the negotiations, you instructed me to ask FINLEY to get experienced regulatory counsel to weigh in on this issue. Is that right?
Yes.
Why did you and your company give me that instruction?
Because we're serious in protecting the rights of our lessors and the correlative rights. We felt like we're not being addressed.
All right. And are these technically difficult issues to address, in your view?
Yeah.
And was that view formed by examining the mineral leasing plan and going through the bid process with the state?
Yeah. So we did all that.
And what's the and what else occurred in that email? Was there an attachment?
Yes.
What was that?
There was an attachment. I believe this is one I made for the 40-acre proposal that if we just do the portion of the river that a river runs through your lot, so why not include that to make a 40 just like the rest of the base of the 40-acre spacing? It seemed like a no-brainer. So I said, run that up a flagpole, Tony, and so you forwarded it on.
Okay, and so the difference here that between our previous proposal, which was rejected, and this new proposal was that rather than including both banks of the river, we're just going to do the west bank and the east bank.
Objection, let the witness testify.
Yes.
Sustained.
Can you restate what? I don't know what I'm answering now. When he says sustained, does that mean?
I believe it's just Mr. Hunter's going to try to not give the impression of leading you as a witness. So.
Reword the question.
Okay. So what's the difference between the 80-acre and the 40-acre proposal?
It's just one bank of the river that goes through your lease. Let's make it a 40. That seems like a fair deal.
Okay. Did we get an answer back on this proposal?
Yes.
When was that?
I'd have to check.
Okay. If I showed you an email, would that help you?
Yes.
Okay.
April 29th.
Okay. Is that an answer from FINLEY?
Oh, that's actually you.
Yeah, you should. Why don't you read that for a second and refresh your recollection about that?
Vice Chair, the division is having a hard time seeing how the last 7 months were spent in email conversations between FINLEY and International Petroleum is relevant as to whether or not commingling should be acceptable in this instance.
Agreed. Mr. Hunter, I would ask you to maybe cut to the chase and show how this pertains to the commingling issue, please. Thank you.
Sure. Mr. Wixom, why did we bother negotiating with FINLEY regarding voluntary pooling rather than ignoring the issue and waiting for them to bring a hearing on the commingling? Why did we proceed this way?
It's the just seems like a waste of time where if you just go fight with the lawyers make a lot of money, but there's nothing gets done.
If there was a voluntary pooling agreement, would commingling be an issue?
It would not.
And if if we had another meeting where a voluntary pooling agreement was made, what would your instruction to me be on the commingling application?
Actually, I take that back. It would be if we had the data. If they showed us the data, then there might be an objection to commingling. I don't know.
But if we were able to come up with a voluntary agreement, what would your company's instruction to me be regarding the commingling application?
That we're okay with it.
Just one more time for the court reporter.
Oh, that we're agreeable with it.
Right. So that if a voluntary,
if we're protecting the rights of our lessor, then we feel okay with that it's not encroaching or upon their minerals.
Right. So a voluntary pooling agreement, which negates the necessity of dealing with the river boundaries, would also negate the necessity of dealing with commingling.
Yes.
All right.
Just, if I may ask a question, given
Sure.
that there's common ownership at all depths in the Wasatch and in the Green River, I'm still not quite clear of this connection to the commingling piece. If you could maybe.
Are you talking to me, Richard Borden?
Yes, I will.
I'm not an
pose that
expert
question
witness,
to you,
but to my understanding is that different zones have different drainage patterns. And so you might be going farther than, there's some wells just a mile and a half to the south, 588,000 barrels of oil out of one vertical well, just under 5,000 feet vertical, and 4.5 billion cubic feet of gas. So I'm not an reservoir engineer, but I think that's going more than 20 acres, 40 acres, or 160 acres from the wellbore, that it's draining more. So it depends what kind of formation you tap into or fracture pattern or whatnot. But that's just my opinion as a fact witness.
Okay, thank you. Sorry to interrupt, Mr. Hunter. You may continue.
No, thank you, Mr. Chairman. All right. Was that 40-acre voluntary spacing or pooling agreement ever accepted by FINLEY?
No.
All right. Do you remember when it was finally rejected?
I don't remember the day. Can you refresh my memory?
If I showed you our response to the objection or response to the commingling application, would that refresh your recollection?
Yeah.
Your memory refreshed?
Yes.
So we proposed it on March the 4th. When did it finally get rejected?
July 7th.
July 7th.
2022.
That was 20 days ago.
Yeah.
So up until 20 days ago, we hadn't had an answer on FINLEY from whether or not 40-acre voluntary pooling would be acceptable.
No.
Do you happen to recall when this hearing was filed, when this application was filed to the board?
It's usually around the 10th, June 13th, perhaps.
I told you
June 11th. June
if I told you it was June 9th, would you
I
argue
could only
with me?
guess.
Okay. If I told you
June 9th, I believe you.
Okay. All right.
Pardon?
We're talking over each other.
Okay, sorry. June 9th.
Sorry to interrupt, Mr. Hunter, but I just do want to remind you that clock is ticking. And
I have three more things to talk to Mr. Wickham about, and then we can cross.
We
and then
would
we
like
can
to
close.
preserve our hour if possible for deliberation.
Yeah, my understanding is that we got to be done by 5. Do you want your hour to go? I've got 3 more slides to show him. They've been stipulated that I can show them. Mr. McDonald's done that. We're going to breeze through them.
Okay, thank you.
We're right at the end here. All right, thank you. All right, Mr. Wickham, I'm going to put these up on the board. Mr. McDonald has stipulated that I can ask you about these 3 APD plat maps that we have downloaded from the website of DOGM. Now I'm going to start you off and put this up on the board for, put this up on the TV for the board and for Division and Mr. McDonald. I have previously shown this to Mr. Doucette as a demonstrative. I believe you were here for that questioning.
If I may interrupt, I don't know, is the board seeing? There we go. Thank you.
Yeah, it's taking a minute for my computer to do the duplicating. All right, there we go. All right. So, Mr. Wixom, we showed this a little earlier during our discussion with Mr. Doucette. You see that blue line?
I do.
What is that marked on the map?
It says the Green River.
All right. And do you see the yellow highlighted square?
Yes.
What is that?
That is the
Objection.
drilling.
First of all, foundation, did Mr. Wixom prepare this?
Yeah, I highlighted that.
No, but did you prepare this survey map?
No.
Okay. Secondly, I would object on its relevance because these are APDs do not pertain to the 3 wells at commingling.
The division joins in this objection.
Sustained. If we could just focus on the wells at hand.
I'm sorry, maybe I'm confused. I thought we had an agreement to stipulate that I was able to question Mr. Wixom on these 3 exhibits that I previously showed you while I was examining Mr. Doucette.
You did examine Mr. Doucette, and I had the same objection to the relevance of it. And if Mr. Wixom didn't prepare these, then these aren't his plats. I don't know why he's testifying to them.
Can I lay a little foundation to help with that?
Yes, please lay the foundation.
Right.
I'm sorry. Go ahead.
Thank you, Mr. Chairman. I'll be quick about the foundation. Mr. Wixom, you previously testified that part of your job is going through public records and collating and creating maps for your company.
Yes.
One of the public records, correct me if I am wrong, is the records of the Division of Oil, Gas, and Mining.
Yes.
And you look at GIS maps if they're available. You look at plats and APDs.
Public
all the
land
time.
surveys, all types of stuff. Yeah.
And one of the things that you look at routinely are APD plats.
Yes.
Did you access the Division of Oil, Gas, and Mining's publicly available records and find this map?
That's right.
Did you print this map off?
Yes.
Did you give it to me to show the board?
Yes.
Did you put the yellow highlighting on that little square there?
Yes.
Thank you. That shows the basis.
What's the yellow square, Nate?
The typical drilling window in a square box, usually.
That river line goes through that drilling window, doesn't it?
It does, according to the surveyor that's licensed in the state of Utah.
All right. So the surveyor licensed in the state of Utah put the river through the drilling window.
Yes.
Do you see where the bottom hole location is for the well?
The bottom left of that drilling window box.
And how wide is that box supposed to be?
200 feet on each from the center, so 400 feet wide total.
And what's the setback supposed to be from any property line?
460.
Is that bottom hole location inside the yellow square? I can
Yes. Yes, I see it in the zoomed up. Yes.
Is that less than 460 feet from the river?
I think I need you to zoom.
Again, Mr. Chairman, I'm going to object to the testimony in this exhibit as to its relevance, even though Mr. Hunter has now set the foundation.
I'm going to let Mr. Hunter continue just because let him use his 10 minutes to what he sees as his best ability. He knows that we don't have much time, but I do leave some time for summing up because I'm still not sure what you're requesting of this board.
I figure if there's half hour for me and half hour for Fred, that's more than adequate. And that should get us right to 5, right? No?
No, we need a time for deliberation. I thought you were going to be finishing up here at 4, so we could be done. We could deliberate till 5.
My understanding was that you had the room till 6. I understand you had the room till 6.
No, but the court reporter leaves at 5, and she needs to be in place for us.
All right,
when you make a motion. Apologies for the confusion.
All right, real quick. Next one that Fred's already seen. 500. Do you see the footage at the top?
Yes, I highlighted 522 feet.
All right. What's that number supposed to be if that drilling window is in the center of the section?
Typically, if you go by the sighting rule, it's 460 plus another 200 to get to the center.
Is that drilling window in the center of that lot 12?
No.
All right. The drilling window seems to have moved south, doesn't it?
It did.
One more time here. This APD plat, we've got the west bank of the river. Is that correct?
Yes.
All right. What's that depicted as?
I can appreciate it. Oh, it's a red. I mean, sorry, blue.
All right. And what's the red line?
The red line is the 460 feet from their as surveyed blue line.
All right. And what's the triangle line in the middle?
The triangle are calculated points, which I can appreciate. There's more detail on this map. So it.
And you previously testified that you looked at a lot of old maps, a lot of old surveys, and a lot of other relevant maps to the river.
Yes.
What do you think that line, that the dotted line is with the triangles, based on your research?
Some past survey, like through the BLM, or I'd have to double check. I don't know exactly what it is.
Through
Which
your
survey
research,
it's from.
Yeah. Through your research, is there any geological feature that probably corresponds to?
Oh yeah, the river runs through it.
All right. So there's two rivers on this plat, right?
Let's see. This one is one
edges.
river. Yeah.
There's two edges of the river.
Yeah.
A blue line and a triangle line.
Two representations for the river on this plat. Yes.
And which line is the setback based on?
On the blue one.
Thank you. No further questions. Fred.
I'd like on the record that I'm objecting to that whole line of testimony regarding those demonstrative exhibits on the basis of relevance, just so it's on the record.
Yes, it will be on the record.
Okay.
Mr. McDonald, do you have any questions for this
I have
witness?
cross-examination, yes. Okay. First of all, Mr. Wixom, you're not a surveyor, are you?
I'm not.
Okay. Secondly, I'm going to direct your attention. I have provided, Paul, if you could switch to my computer, I'd appreciate it. I'm going to direct your attention to what have been marked as Rebuttal Exhibit L, was submitted to your council and to the board earlier this morning.
If you just want to throw it up, Fred.
Well, I'm waiting on Paul to switch the computer. I will represent to you that it is a copy of your lease that I obtained from the Uintah County records. Do you have any issue with that?
Do not.
Okay.
Go ahead and answer the questions if you see it.
All right. First of all, is you took that, is that lease currently in producing status?
No.
It's not. So there hasn't been any drilling along or any agreements that have been spaced or pooled with that lease. Is that correct?
It depends how you look at the permits. There's about 5 penetrations that are close to the river.
Right, but
we're going to come back later.
It's currently not spaced, and there's currently no production allocated to your leasehold. Is that correct? Okay, all right. Again, Paul, could you please switch to my computer? Thank you. Okay, I'm going to direct your attention, first of all, to section 7.2 on page 8, which is shown at the bottom paragraph here. That's the no surface occupancy on that. So when you acquired this lease, you knew that you would have to directionally drill to access your leasehold. Is that correct?
Correct.
Okay. And then I'm going to direct your attention to paragraph 6.7, which is on page 7, which deals with offset wells. And there are 3 things listed there that you're supposed to do if you think there's drainage. Is that correct?
Correct.
And you acknowledge that it's your obligation to either drill on the lease premises, pay compensatory royalty, or prove to the DFFSL that there's no drainage occurring.
That's what it says, yes.
Okay, so you had that lease obligation to take those steps, correct?
Correct.
Okay. On your protest, did you mail that directly to Finley?
Which protest?
The protest of the commingling.
It was emailed.
It was emailed to Finley? Mr. Arndt testified he didn't find out about the protest until January 27th, and he responded on January 31st.
What's the question?
The question is, did you or your council mail the protest to Finley when it was submitted to the division?
I don't know.
Okay. Do you have any technical engineers or geologists on staff?
Not on staff.
Did any of them look at anything around the wells that you say that you are participating in around this area or look at any of the spacing orders around this area to determine if a drainage issue might even arise?
Say again?
Do you have any technical support to show that there is any drainage occurring from these wells?
From these wells, no.
And do you have any technical staff that has reviewed other wells that are producing public records? You say that you review public records, other spacing orders in this area to even determine if a drainage issue may arise?
I've seen other hearings before.
Okay, and you've seen those other hearings, but do you have any technical people that have analyzed those?
No.
Okay, that concludes
on that. Well, we have in the past, but
not with respect to these wells and the analogies.
Not in these 3 wells, no.
All right, that concludes my cross-examination.
I have 2 redirects, and then we're done. If that's okay. Oh, division. I apologize.
You can do your redirect first if you'd like.
Okay, yeah, just 2 brief ones.
Mr. Hunter.
Mr. Wixom, on the riverbed land, is directional drilling the only option for the no surface occupancy in order to get that into production? Can you only directionally drill, or can you do something else? What's the other option you have?
Are you talking about in 6.7?
7.2. What goal were we trying to pursue the entire time with FINLEY?
Yeah, waiver,
what proposals did we make over the course of those many emails to get the land into production?
That we can voluntarily develop together.
Right. And would a voluntary spacing unit also get the land into constructive production without needing to directionally drill?
Yes.
And one more question on the spacing on the offset wells, drilling to completion on the lease premises that would be deemed necessary. If you space it, is that drilling under the, would that qualify as drilling under the lease?
Yes.
No further questions.
I'll keep this brief because I know that we have some time constraints. Mr. Wixom, you have stated that your lease with FFSL came with certain lease obligations that we're currently looking at that included ensuring that the area was not drained. Is that an accurate statement?
Sounds right.
Okay. And then you've also stated that the lease was vague as far as where the boundaries were because of these title issues that we've been discussing. Is that accurate?
Yes.
So would it be accurate to say that you took on an affirmative obligation to ensure that nothing got drained without knowing the exact contours of that obligation?
Yes.
And then your counsel complained of or explained that the 10-day window with which you had to protest an APD leads to some challenges. Did you understand that you only had a 10-day window to protest APDs when you took on that affirmative obligation with FFSL?
It didn't occur to me.
Okay. Changing gears, Mr. Borden asked you a question earlier concerning the commingling, and you stated that there'll be different drainages from different depths. And so I'd like to discuss that for a moment. Do you have any technical background in geology or petroleum engineering?
No.
What is your foundation for that statement?
Just seeing different wells produce different amounts and different zones. If you look at different reports, different zones have, say, more sandy, more porosity, more permeability. It makes drainage patterns, it enlarges drainage patterns. Instead of a brittle rock, you can drain a lot more. And up in the north, there's an area where it's 40-acre spacing, and there's 2 wells per 40, and they effectively drilled everything out there. But for some reason, the drainage pattern goes over the aliquot parcels. I don't know how it does that, but drainage patterns don't listen to lease boundary lines.
Certainly they don't. So you don't have a technical expertise to be speaking on differential drainage between 2 different depths, and you have not had any technical experts review these particular wells to determine if there would be differential drainage from different depths for these wells.
Correct.
Okay. Yeah, that concludes my cross.
I've got one redirect on that one, and this is going to be a quick one.
Proceed.
Nate, why didn't you have anybody review the well data to find out if there's drainage?
we thought we had a deal with it. We're working with them diligently, and we were negotiating, going back and forth, and they said we're going to be in 35%. In 6 wells, we're going to be 35% owner in those wells until we got the ultimatum to, okay, we're going to.
And does your company have in its possession data that you can review to determine drainage patterns?
We can hire people to do that.
But do you have the data to work with?
No, we don't.
No further questions.
Board, any questions for this witness? Go ahead, Ms. Garrison.
If commingling was not approved, how would they have to produce one zone and then the other zone? How would you, bring them into production? Commingling, I'm assuming we would lump everything together. But if you don't do that, how do they disperse when the time comes based on spacing or whatever?
I think that would be for their geologists. I don't know I don't know if they've allocated per zone how much production is coming out of each zone.
But is that how you'd have to do it? If commingling were not approved, how would you disperse royalties on that well?
Again, without spacing, it's the rule of capture. And the rule of capture is there's no difference in the ownership between the Lower Green River and the Wasatch, so the people would be the same regardless of what the production was from each zone.
And so you would not allocate?
No, there's no allocation. It's the same people that get paid.
Thank you.
Any other questions from the board? Seeing none, yes.
Hey, Mr. Chairman, I just have a very short rebuttal. I'd like to recall Mr. Atkins.
Okay. We're running out of time.
I understand. It'd be very quick.
Okay.
All right. Mr. Atkins, are you still there? No, please tell me he's there. He's not?
We could come back next month, if that's agreeable.
What I will do, as long as Mr. Hunter will stipulate to this, is rebuttal exhibits I and J. Rebuttal exhibit I is a visual representation of spacing orders where there is 10 or 20 acre well density that this board has recognized both the Lower Green River Wasatch portions that we're talking about. And exhibit J is the true and correct copies of those orders that were ordered by the board. If you'll stipulate to that, then I don't need any more rebuttal.
I will stipulate that on the condition that my objection to that would be just because it's 20 acre spacing north of the river and around the place, it's not necessarily the proper drainage.
Well, Mr. Atkins is there. I just saw him for a second.
Yeah, Julie's raising her hand.
Shay, are you on now?
Yes, sir, I am.
Okay, real quick. Turning your attention to what has been marked as rebuttal exhibit I, did you prepare this or did FINLEY personnel prepare this with your review and input?
Yes.
Okay, and would you please explain to the board what this represents?
I can't see that on my screen yet.
Okay, it's the plat of the 10 and 20 acre well density offset.
Yeah, so this exhibit represents 5 spacing orders. There we go. 5 spacing orders in the vicinity of the discussion area today. Some of which FINLEY testified to and prepared, and some of which others have testified to and prepared and approved from the board. The green shading, the green outlines, lands represent 20 acre equivalent well density approval, and the kind of pinkish red areas represent 10 acre spacing equivalent density. And so the testimony from those exhibits, which is a public record and approved from the board, shows that drainage patterns and drainage would justify these spacing densities.
And that this covers the same formations that you're desiring to commingle?
Yes, it does.
And were you involved in the preparation of some of the geologic testimony in those causes?
Yes, I either testified to or prepared the exhibits for, or managed over the preparation of those exhibits for all the ones that Finley was involved in.
And is it your opinion, is there any differential between the rock in these causes and Section 12 that you've seen?
It's my opinion that this is like rock, similar area, similar depositional environments. This is analogous rock.
Is it fair to say that this is also additional justification for why you believe that these wells are not draining beyond Finley operated leaseholds?
Yes, sir, it is. That's my opinion.
All right, that concludes my rebuttal.
Okay, thank you. I guess is now the time for summing up.
Well, one other thing, I need to get my rebuttal exhibits I and J admitted into evidence.
So admitted?
No objection.
Oh, thank you.
No objection from the division. And in the interest of time, the division recommends closing statements be 5 minutes or less per party.
I think that sounds very reasonable. Huh?
Back to me?
Proceed, yes.
Okay. Well, again, as I said in my opening remarks, the key to here is to distinguish commingling and spacing. And I believe Mr. Wixom made our case for us in his testimony. He said if we had voluntarily pooled, the commingling would go away. So if you pool both formations, then there's no problem with the allocation. What they're saying is we need the 40 acres. We need to get our acreage included as part of this. Okay. And as we've stated all along, that obligation is on them to come and seek spacing. You've heard from our witnesses, number one, the geologist, who's an expert, that there is no geologic indication that would differentiate the two formations. You've also heard you have a surveyor who went out to the field and measured 460 feet away. And again, it's been very clear and set by law by the Utah Supreme Court in the Cowling case that spacing is what defines correlative rights. And until there's a spacing order, they have no correlative rights to production in these wells. And it's their duty, as was made clear in the Cowling case. The quote is in my brief that I filed last Friday. An owner's failure to take action to establish and protect his or her interest in production prior to the entry of a spacing order constitutes a waiver of the interest until a drilling unit is established. And there is no legal obligation, even though Mr. Hunter cites the provision in the APD. The reason it says they requested is because there's no legal obligation for an operator who believes there's no drainage going on to go seek spacing. Why spend the money if you know that you're not draining there and it's just your parties that are involved with the production? The burden is on them to do that. And Mr. Hunter's tried to turn this hearing into that spacing hearing. They have the obligation. They can either go directionally drill a well. If they think that they're being drained, they can pay compensatory royalty. They have the obligation under their lease to do so. They can also come and seek spacing. Under the Hegarty case, that was exactly the same thing. Hegarty finally came, he got geologists, he got an engineer, he came and testified, and the board said, okay, up to that point, then you waived your rights to production. You had the same opportunities before as you do now when you came to it. That's the same thing that the court said in the Hegarty case is a good law, like a good parent, doesn't, you don't create one inequity by another. These applications have been pending since December. My client wants to produce them. They haven't established anything to refute the commingling application here. And we would ask that the board deny their protest and approve the applications as they were submitted to the division. And we thank you for your time and attention. And again, for your consideration of Mr. Atkins's position so that he could testify remotely. Thank you.
Thank you, and thanks for a very brief summing up. Mr. Hunter.
I didn't time him, but I'm going to try to beat him. So we'll start at the end and then work our way backwards. the commingling application, we have grounds to request a denial of that on two separate avenues. Number one, we're not sure that the well is legally located. No matter what surveys are out there, no matter who's walked off, no matter how many lines you draw on the map, the ownership is the important part. They can testify and they can identify lines on a map and the surveyor can walk across. But the fact of the matter is that they don't know where the ownership line is. It's the property line. It's the lease line that matters. The lease line isn't defined in the lease because the state, the owner, doesn't know because it's sovereign land. It's the sovereign. They have sovereign rights to those lands. They're not going to be defeated by an APD application. It's theirs. They're going to defend it, and they own it. Second part of that is that they're asking for a commingling. You heard testimony that it's 1.6% of the perforations, and they won't say how much oil is coming out of it. There's insinuations that, oh, it's just a tiny bit, but under repeated questioning, he would not say. And that's very strange because that was an attempt for Mr. McDonald to turn this into a spacing hearing by telling you how much that was going to drain. We didn't actually get a number. Again, under repeated questioning, he wouldn't identify it. And at the end of it, it was you had to have a number to say to come up with a conclusion. We're not draining off our lease. He wouldn't do it. Not in square acreage, not in linear feet. He wouldn't do it. We just have to take his word for it that it's less. You don't get to have an expert testimony and an expert opinion and not expose your underlying facts to criticism and analysis. And that is really the key here. They're playing hide the ball with how much oil is coming out of there. Maybe it's nothing. Okay, share that underlying data. And that's the second part of why you need to deny this commingling application. It's an obligation, a legal one, to allocate. It doesn't matter if it doesn't make sense. It doesn't matter if you don't want to. It doesn't matter if there's uniform rocks. It doesn't matter if there's uniform ownership. The state of Utah has not spaced this and therefore has not come to the legal conclusion that the Wasatch is different or the same as the Uteland Butte. You had testimony that the geologist doesn't think it is really in this spot. It's a transition zone. It's kind of a gray area. That doesn't matter. It doesn't have to be logical. It has to be legal. And the same thing for the ownership. Yeah, it may be uniform the whole way down the bore, but we don't know how uniform it is if it crosses lease lines, property lines, because we don't know where those are. And I understand that that may not be the popular opinion or the prevailing analysis, but that's the facts. The facts are if you want a legal well, you put it in the window. The window is the window. You don't get to slide it around. You don't get to run a river through it and call it, well, we're still in the window, so it must be okay. No. The window's in the middle of a quarter section or substantial equivalent. You don't get to move that around. You don't get to drive lines through it. And then you don't get to move a river. On the other side of the river, that was our final slide. There's two rivers there. There's two river banks. One from whenever. One that was drawn on there. And the well site is 460 feet from the wherever line. Two grounds to deny. One, their well's not at a legal location, and we need to address that before anything else happens with commingling, correlative rights, whatever. Second is the allocation obligation to report it, to keep track of it, to let people know what's actually going on in the formations is not optional. It's not elective. It's mandatory. And they said in their own applications, we don't think we have to, and we're not gonna. Thank you.
Thank you. You were less than 4 minutes.
Did I beat him?
You guys were close.
Okay, all right. Well, it's a tie, Fred.
Okay, concerning the commingling, the specific rule at issue right here states that the application for commingling must be accompanied by a description of the method used to account for and to allocate production. In this instance, the division understands that the ownership of the minerals is continuous at both locations, or at both depths, rather. And so it was proper for the allocation, the description of how the planned allocation would be to basically say, well, it's the same ownership, so we're just going to pay accordingly. And so the division would have approved this administratively, but for the objection. Nothing here in this hearing has changed the division's position. The division still would have approved it, but for the objection. It's the board's decision to decide whether to approve or deny this commingling application. the division notes just a couple of things. First, by the terms of the lease with FFSL, International Petroleum understood that it had an obligation to defend and protect from drainage, and yet it failed to protest this during the APD process when it would have been more proper. As Mr. McDonald has noted, correlative rights are not completely mapped out or explained until spacing occurs. The division disagrees that the correlative rights are not in existence until spacing occurs, but certainly the correlative rights do not have distinguishable boundaries until spacing occurs. Spacing should likely occur in this area, and it's likely the role of these parties to either figure out a voluntary pooling or to seek spacing. Thank you.
Thank you very much. I think we are going to need to go into deliberation, and we will try and be as prompt as we can. Thank you for your time, and we're off the record.
Hey, Wade, if you'd like, let me try patching Lee in. Hold it. I'm just reading.
clean that up and then I'll go.
Yep.
What day does that go? Paul, are we good to go? Okay. All right, we're back on the record. I believe there's a matter of some of the exhibits that need
Yeah, we have
clarification.
we have some cleanup, Mr. Chairman. I apologize in the rush to get through everything. We have one exhibit that did not get admitted into evidence. That's rebuttal exhibit L, which is the state lease to International Petroleum. I would move for its admission now.
Granted.
No
Any
objection.
objections?
No objection.
No objection.
So yes, it is admitted.
I too have a little bit of cleanup, Mr. Chairman. In the rush, we didn't admit any of our exhibits. So I'll move for admission of exhibits 1, 2, 3, and 4. We did not address exhibit 5. I'll skip that and then move for admission of exhibit 6 from the previously submitted exhibits.
Any objections?
Yes, the only objection would be to exhibits 3.1 and 3.2 on the grounds of relevance.
Again, my same standard response is we're talking about the awareness of the location of the river and its relevance to the process of approving or denying an APD based on pretty obvious map problems.
Division, do you have any objections to this?
The division mirrors Mr. McDonald's objection. The review for an APD is irrelevant to the commingling request. And so, yeah, we object to admitting that one into evidence, but the rest of the exhibits are fine.
And to address his objection to that, we talked about how there's a lot of questions about notice about APD and who gets notice, and it's on the website, and you only have 10 days. So I think the review of an APD and what actually gets put out there is quite relevant.
I am going to sustain those objections. Okay, I guess the next order of business, I would entertain a motion from somebody. Oh.
I believe Mr. McDonald only objected to 3.1 and 3.2.
Yeah, it was so
Correct.
exhibits 1, 2, 4, and 6, correct, Tony?
That's right.
Okay.
Yes, they were admitted except for 3.1 and 3.2. Huh? Okay, I guess I could listen to a motion if one is in order.
Yes, I'd like to make a motion. The motion is to approve the request for agency action of FINLEY to commingle the Green River and uppermost Wasatch on the 3 Lazy River wells requested in cause 478-01, and to deny the objection based upon insufficient technical evidence that did not provide any burden of proof.
All those in favor say aye. Aye. Let the record show that was unanimous. Board counsel, I would task you with writing the order on this matter. Oh, let's back it up.
I'll second that motion.
Thank you for your second. All those in favor say aye. Aye. Okay, let the record show that was unanimous. Board Counsel, I task you with writing the order on this matter. And I just do want to remind everybody here, there is still a legal remedy to protect correlative rights by seeking a spacing order, either a voluntary one or by reappearing before this board. And I think that concludes that matter. There's just one other item on the docket. That is docket number 2022-015, cause number 132-04. This has been continued to the 26 October 2022 meeting. And I guess I would entertain a motion to adjourn. Then we are off the record. Thank you very much for an interesting day.
You gonna do it again? You gonna do this? You gonna do this thing again? You ready? Okay. All right. Yeah.